Either the legislature or the regulatory body makes a law, a written law.
When we went through this technology, we thought we should do it. We should have it in Bombay. Corporation is willing it. My commissioner is very much for it. They are willing to give a fund for it. But the question was that what is the legal status?
इस बात को सुनिश्चित करने के लिए कि भारत में अभी ये जो वर्चुअल ऑटोप्सी की जो प्रक्रिया है ये पूरे सार्क देशों में भारत में पहली बार शुरू हो रही है।
Either the legislature or the regulatory body makes a law, a written law.
When we went through this technology, we thought we should do it. We should have it in Bombay. Corporation is willing it. My commissioner is very much for it. They are willing to give a fund for it. But the question was that what is the legal status?
इस बात को सुनिश्चित करने के लिए कि भारत में अभी ये जो वर्चुअल ऑटोप्सी की जो प्रक्रिया है ये पूरे सार्क देशों में भारत में पहली बार शुरू हो रही है।
It's an institute which has really bothered for the medical community.
The Institute of Medicine and Law. Medicine and Law. For putting on this wonderful show. This will, I'm sure, in days to come, be eye-opener for the government as well.
Justice means which is just for both the parties.
I think IML have succeeded in their mission to a large extent.
It's an institute which has really bothered for the medical community.
The Institute of medicine and law. Medicine and law. For putting up this wonderful show. This will, I'm sure, in days to come, be eye-opener for the government as well.
Justice means which is just for both the parties.
I think IML have succeeded in their mission to a large extent.
It's an institute which has really bothered for the medical community.
The Institute of Medicine and Law. Medicine and law. For putting up this wonderful show. This will, I'm sure, in days to come, be eye-opener for the government as well.
Justice means which is just for both the parties.
I think IML have succeeded in their mission to a large extent.
It's an institute which has really bothered for the medical community.
The Institute of Medicine and Law. Medicine and law. For putting up this wonderful show. This will, I'm sure, in days to come, be eye-opener for the government as well.
Justice means which is just for both the parties.
I think IML have succeeded in their mission to a large extent.
Which will take the better part of an hour. We intend to have a second round with just a couple of minutes to 3 minutes for each panelist, where we'd engage on 3 or 4 key topics of discussion, which I shall note down, and we shall take it forward in round 2.
Good morning, everybody, and a warm welcome to all our distinguished participants and all our online viewers. We have all gathered here virtually today on Sunday, the 5th of July 2020, to participate in the 5th National Convention on Medicine and Law 2020. The whole world is going through challenging times, one which is questioning and probably changing the very nature of our existence, the way we have been living our lives. And doing things the way we did them may no longer be practical or even applicable, and new ways must be found. They are being found. This change is also visible in the National Convention on Medicine and Law, as we are going online for the very first time. Yet, as in the past, today we will attempt to bring clarity or explore new solutions to a few issues faced by the healthcare community and which are importantly affecting patient care. It is my honor and privilege to welcome Justice Sunil Ambani ji. Justice Ambani ji has been the Chief Justice of Rajasthan High Court and also the Chairman of the E-Committee of the Supreme Court of India, which is tasked with modernizing all the courts in India. It is also my honor and privilege to welcome Dr. Bhagwat Karad, Dr. Ramapati Tripathi and Dr. Mohammad Javed, all members of Parliament and all qualified doctors. It is our pleasure to have you here. I would now like to invite our chairperson, Justice Ambani ji, to inaugurate the 5th National Convention on Medicine and Law 2020. Justice Ambani ji, over to you. Can we have a few words from you now? Sir, you'll have to unmute yourself. All people will be on mute by default. You will have to unmute yourself before you start talking, please.
Can you hear me now?
Yes, sir, very clear.
Good morning to everyone. Distinguished members of Parliament, distinguished doctors, distinguished panelists, legal experts, and those who are interested in this conference, online conference organized by Institute of Medicine and Law, the National Convention, 5th National Convention on Medicine and Law. I must congratulate you for choosing a very relevant topic, organ transplant in India, legal issues and solutions. I am here actually to hear to distinguished panelists speak out their own views on the legal issues and solutions. Just in order to open the session, I would like to tell you that we have a very robust legislative instruments on the organ transplant. Is the Transplantation of Human Organs Act, which was enacted in 1994, and the rules were framed in 1995. The rules were thereafter amended in 2008, and with the transplantation of tissues also coming in, the rules were again amended in 2011, which were known as Tissues and Organs Rules. The rules have further undergone amendments in 2014, prescribing the various formats and forms also for the appropriate authority, the recipients, donors, and the hospitals. This act was actually to provide for regulation of removal, retrieval, storage, and transportation of human organs for therapeutic purpose and for prevention of commercial dealings in human organs. While I was going through the act and the rules and reading the articles for last few days, I found that instead of making the procedure simpler and simpler, the various rules and the amendment in the rules have made it more stricter, and the compliances are becoming more difficult. There is no difficulty in living organ because there the rules are simple. Both the parties can wait, although the waiting period in India of the registered persons requiring the transplants is something like 3 to 5 years. But what is really happening is difficult is the cadaver transplants. Cadaver transplant is still at a nascent issue, and we are facing a lot of problems in cadaver transplant matters because of religious, because of emotional issues, because of various other issues. I think that the rules should be made more simpler, and the burden should, instead of being placed on the doctor, should be placed on the appropriate authorities and the hospitals who are carrying out the management. The numbers of the persons waiting for transplant is unbelievable. At present, 93,000 persons are waiting in the waiting list of NOTO, the organization for transplant, where the waiting list is 3 to 5 years. We also need a very vigorous swap and pair program for the purposes of transplants. Now, the transplants are not limited only to kidney, lung, liver, heart, spleen, but they were also gone to tissues and also the stem cell. Now, this is a COVID area where, as initially we came to know from Dr. Parag and Maria from Spain, that the number of transplants have gone down because of the severity of the COVID pandemic. I think it is not a very encouraging situation. Today we have distinguished panelists. I hope that they will be bringing in a number of issues, not only legal issues, but other issues also, which may be taken into consideration by all of you participating in the program, and especially those who are experts, and the white paper which will come out will be very useful. Personally, I feel from my long experience at the bar, where I practiced for 25 years and was a judge for 15 years, that human organ transplant requires not only a very serious attention from the legal fraternity, the procedure should be made easy, the doctor should be made less accountable, and the recipients should be given much more consideration. Thank you, Dr. Mangal. I'll be participating to hear the suggestions and solutions.
Thank you so very much, Ambane ji, for your kind words. I would now like to invite Dr. Parag Rindani to open the session and start the proceedings. Just a few words about Dr. Parag Rindani. Dr. Rindani, I know him for many years now. Very good doctor, a very good human being. Whenever I have called upon him to, he was there for moderating the NCML session in 2015, in 2016. A wonderful moderator, a wonderful human being. He is the CEO of the Wockhardt Hospital in Bombay, and he is also NABH assessor and a very strong advocate in trying to bring about changes which are helpful for the healthcare industries and for the patients. Over to you, Dr. Rindani.
Well, thank you very much, Ravindra. At the very outset, I'd like to pay my respects and regards. Let's not forget that today is Guru Purnima. For the benefit of Dr. Maria and Dr. Ajit, Guru Purnima is a day which is celebrated as a special day where we revere our teachers. And there is a shlok in Sanskrit with which I'd like to kick off today's proceedings, which basically says, Anna danam param danam vidya danam ataha param. Anne nakshanika trupti ya vidyaya jivachaha. So it basically means that if just giving food to people is probably going to satiate him for a day, but essentially giving knowledge to a person is going to help him throughout his life. To extend the corollary, probably even giving an organ for a person is going to help him throughout his life. So on that note, we'd just like to start off. I miss my convener today, Dr. Ravi Shankar, who probably will log in sometime as soon as the difficulties at his place sort of tide over. But to essentially move on, we'd like to, for the benefit of all our viewers on YouTube, as well as for the benefit of all our panelists, I will be introducing as you'll be invited to speak, rather than spending a lot of time on introducing everybody up front. As we go ahead, we'd like you to take 3 to 4 minutes to essentially dwell on the key legal challenges that are facing organ transplantation in India. We'd also like to have a perspective from overseas as to how other countries are dealing with these issues. And probably we need to take a leaf out of their books and their learnings. As we say, there's no use reinventing the wheel. So with due permission from the chairperson, Justice Ambani ji, I'd like to start, and we'd like to invite in no particular order, but there are certain requests which have come in terms of time clashes with other commitments. I'd like to start off with inviting Dr. Lalit Shah, who is the convener of the Legal Cell, Urological Society of India, extremely passionate about medico-legal education for doctors. So Dr. Lalit Shah, you can unmute yourself, and with no disrespect meant to anybody, I've been told to keep a track of the time. So I will ping you when you're about 30 seconds to closure. With respect, sir. Dr. Lalit, over to you, sir.
Okay, thank you. Thank you very much, Dr. Ngani. Thank you very much for the opportunity provided for a very, very important topic to the Institute of Medicine and Law, because this is a burning issue. The transplantation in Indian scenario, the demand and supply there is too much of a gap. Supply for the material as well as the medical teams who are performing the transplantations. What is happening is, I will be touching upon the two issues which will be important. Now, number one is that for the small volume centers, or which could probably become a small volume centers in tier 2 and tier 3 cities, where ultimately if it percolates, it will be of a great help. And that is where the fear psychosis is there among the doctors, that for few cases, why should I get into the trouble of a possible legal issues? So like in cancer surgery, they have two different teams. One who is performing the surgery and one who is doing the repair of the surgery, so that the person who is performing the surgery is not making any compromise for the repair, and the cancer surgery is done in a proper way. Similarly, if the team who is performing the transplantation is saved from the possible legal hassles about any racketeering which is possibly going on in the transplant center, that would be very much helpful to them, because then they would be able to focus purely on the medical treatment and the transplantation program. And with this, so many small centers would also develop in the tier 2 and tier 3 city, and small centers percolating in the tier 2, tier 3 city would be very great help for development and the progress of the cadaver transplant program. That was my point number one. And number two, for the cadaver transplant program, the families of the deceased person should be given an opportunity or some sort of incentive, not necessarily financial one, but that in case they or their family requires an organ, they would be given a preference. That would be my two important points for discussion. Thank you very much.
I think that's very neatly summed up, Dr. Shah. I respect both the points you've made, and I think these will go a long way in putting together the white paper that we're looking at. I think one of the maximum work that's been done in our country has been done by the Mohan Foundation. I'd like to invite Dr. Sunil Shroff to kindly give his views and the challenges that he personally has faced over these years, and what are the changes that we'd like to see. Over to you, Dr. Sunil Shroff. He represents Mohan Foundation, which we are all aware of. Dr. Shroff, we can't hear you very well. There seems to be an issue with your audio, sir. Sir, it's coming very garbled. If you could log off and log on again, sir, that might help, Dr. Shroff. Okay, Dr. Shroff, we'll come back to you in a minute while our admin resolves the issue. Tina, you will take over, please. Yeah. And I'd like to invite, do we have Dr. Gursani? Dr. Gursani, Dr. Roop Gursani.
Yes, I'm here.
Is an extremely well-known neurologist in Bombay, works at Hinduja Hospital. I don't know whether he recalls, he's treated me also in the past. And over to you, Dr. Gursani, for your views on organ transplant.
Right. So I'm going to kind of, actually, thanks very much for having me on board. And it's a bit of a challenge because I'll have to actually toggle between two meetings simultaneously. But I think that's probably an occupational hazard nowadays. As it turns out, I'm going to just make one single point, which I think needs to be highlighted and flagged for action sometime during this whole period. And that is the surrogate decision making hierarchy. Let me explain. Let me give you a word picture. I'm not sure if you guys remember, but I do. This picture of Jaya Jaitley, who used to be George Fernandez's partner, at the gates of his residence, begging to be let in, because the wife whom he was estranged from had kind of come back after the onset of George Fernandez's dementia, and she was now, she had taken his life over back again. Okay, so remember, surrogate decision making is a fraught issue. It's not simple, and in times of crisis, it can cause huge chaos amongst treating teams, whether it's on transplant, end of life care, across the board. What do we have? We have a very bland statement in THOTA, which kind of lumps together all kinds of relatives, including the person who's paying the bills, makes no hierarchy, and well, whoever is there on the spot has to figure out how to make sense of that. Abroad, almost all jurisdictions legislate on this very, very specifically. A surrogate decision making hierarchy, typically, the standard one will have at the top a court appointed protector or guardian, who supersedes everyone else. The next is the spouse or the accepted spouse, and so on. Then, of course, come adult children, adult siblings or parents, then other relatives, and then obviously next friend. Now, this kind of a hierarchy has not been put together in any Indian official document except till 1 month ago. And 1 month ago, the All India Institute, and I suggest if anybody of you is interested, you can look up the end of life care guidance document that they put out for their own institution. But fortunately, since it's a statutory body, we can take it that this would be a significant step forward. And one of the things that they've done there is to actually put a surrogate hierarchy. And that surrogate hierarchy actually recognizes not just the spouse, but also the live-in partner. Obviously, in a document like that, they're not going to be able to specify how that kind of the immediacy of that relationship and so on is going to be verified and taken on board. But I suggest to all of you that as part of the document that comes out, we need a surrogate hierarchy for end of life care, for transplant, for all these related purposes to be spelt out, to be recommended, and to be legislated. Thank you.
Thank you, Dr. Gursani. I think we are also going to be discussing today the opt-in, opt-out for organ transplant, which will also look at addressing this issue of surrogate decision making. So we've had very funny incidents as healthcare practitioners. We've seen a first wife turning up and a second wife turning up, and then subsequently huge confusion as to who's the first class legal heir, and then we go to the lawyers, and it's quite confusing sometimes.
Nobody knows.
Nobody knows. So before we move on and I hand over, we go back to Dr. Shroff, I'd just like to recognize and welcome Dr. T.N. Ravi Shankar, who's a faculty of medical law at the Anna Institute of Management and the SRMC NRI Chennai. He is also the founder member of the Professional Protection Scheme of Indian Medical Association, Tamil Nadu State. Dr. Ravi Shankar, we welcome you. Thank you very much for being here today.
Good morning, Tom.
Good morning. I have
Sorry for the late connection.
No, so that's perfectly okay. That's the way we function nowadays. Dr. Ravi Shankar, I will proceed and I will hand over to Dr. Sunil Shroff.
Please go on. Please go on.
Dr. Sunil Shroff, as we know, represents Mohan Foundation. He's founded it and he's nurtured it, I think, exceedingly well. Dr. Shroff, over to you, sir.
Hear you now? Am I audible now?
Absolutely well audible. So please go ahead, sir.
Thank you. Can I get a right to share my screen?
Yes.
So I'm going to just briefly dwell on what are the practical problems we are facing, on the ground, and elaborate a few points on that. And I did hear Dr. Gulshan as well talking about, some of the problems he has he elaborated on. But without getting into too many details, I'll just look at the gaps in the law as we go forward and where we need to really plug in these gaps. Brain death is linked in our country to organ donation and is not accepted as death formally as such. And in India, diagnosis of brain death only occurs if organ donation is considered, but they are both linked together. So what's happening is, especially in the corporate sector, hospitals are having problems switching off the ventilators if relatives say no to donation. So you could have a situation where, the relative, a person is dead and he can donate if the relatives say yes to donation, but ventilators will not be switched off if they say no to donation. This is the situation. And the laws governing the death in India are Registration and Birth Death Act, the Indian Penal Code, and Transplantation of Human Organ Act. Since we're short on time, we did write an article on this, why we need it. And, death is defined as permanent disappearance of all evidence of life any time after live birth has taken place. Can brain death be challenged as a definition? Because not all evidence of life is lost. Heart and lungs are still there, so it can be challenged. That's why the clinicians are a bit worried in certifying death when somebody says no to donation, so they don't switch off the ventilator. And the brain death certificate is not accepted as death in some of these other claims like insurance claims and any other purpose. So what we need is we need to bring brain death into the definition of Birth and Death Act. I think it is undergoing amendment, the Birth and Death Act in 2012. I think it's still in the draft stage, so we could include brain death in the, where you can say all evidence of life lost, including brain death. If you say that, that should be enough. Other problem we are having practical problem is in post-mortem, where the inquest is required. What happens is there is a lot of delay in handing over the body. So when a relative say yes to donation and then there is a post-mortem, it can lead to a delay of 24 to 36 hours. And that can cause a lot of problems to families, and many families withdraw their consent after saying yes to donation. We have seen that. And 76% of disease donation in Tamil Nadu, at least in the registry which we saw, were medico-legal cases. So they'll all require, some kind of inquest. What we need is so, and that's the other problem. I don't want to go into detail. It's a very complex slide of how post-mortem takes place in various states. The third point I want to bring is, but I have Dr. Gulshan Sahni also to some extent has mentioned it. Who is next of kin to give permission for donation? And you're seeing two wives were there and so on. We not defined that. We had a 12-year-old who had an RTA, and was brain dead. Grandfather came forward to give, consent because all the other family members were injured, but the hospital was not sure that they could go forward. And actually keep going on in such cases. We have had multiple such problems. So we need to define who is next of kin in this situation, just like it is done in the US. So we could have a hierarchy of who is the next of kin defined, and that will make our life much, much easier. In US, you have that recommendation in, where they have defined who is next of kin. And I suggest that we bring this in our white paper as well. The other gaps as well, I don't want to go into details because I think I've only given 3 or 4 minutes, but if we need to create guidelines on donation after circulatory death, and we need to have proper guidelines for this. This will improve our organ donation rate in this country. We just need guidelines. The law already has some elements of circulatory death already there. So that can be done. And with this, I will close my opening remarks. Thank you.
Thank you very much, Dr. Shroff. I think these are challenges that we face, whether you're a clinician, whether you're an administrator, whether you're a surgeon, whether you're a critical care physician, these challenges are there for each and every one. And this is something that we deal with day in and day out. So that was very realistic. I'd like to take you over to Dr. Rahul Pandit, who is a very dear friend. He represents the Indian Society of Critical Care Medicine and currently works as the Director of Critical Care at Fortis Hospitals in Mulund. As you know, this is a hospital that's a pioneering center for organ transplant. Specifically, it has made its name now in heart transplant, the leading center for heart transplantation in Maharashtra and in this part of the country. So over to you, Dr. Pandit. Please go ahead.
Thank you very much, Parag. Just that I may have to rush to the hospital, so I'm going to make my points now so that if I'm not there for the next deliberation or I miss out, then I have at least put up my points. I think there are only three things which need to be done. The first and foremost, if we are not going to have organ donation successful, if we are not going to make brain death very, very easy for diagnosing and for the simplicity. As Honorable Justice already mentioned, I think there are three things if we can improve. First is Dr. Sunil has already brushed upon it, that we need to have a universal definition of death. So you can't have death from brain death criteria and from living from circulatory death criteria as termed as two different things. So we need to have the death as a basically a definition in the death and birth registry of Government of India, so that when I'm signing a death certificate as a critical care specialist, I just write patient died on so and so date, so and so time, criteria brain death. I can sort of tick that up, and rest of the forms are already in place. The robust forms are there. The robust process of declaring brain death is there. That did not change. So we should have that, because right now what is happening is that because it is this death is defined in the TOHA Act, many intensive care consultants are basically reluctant to sign the death certificate. It's a problem. Second thing is that we need to have the ability to switch off the
Dr. Pandit, we are not, your videos and audio is not streaming, sir. We are not able to hear you at all. Can admin please pitch in and support if possible? No, remotely.
I think that would be a network issue at his end.
Yes, yes.
So I think we'll have to move on, please.
Yeah, we'll come back to Dr. Pandit. I think he's making some very succinct points which could probably go in toto into our paper, and we'll look at that separately. And it's my privilege to introduce one of the most active members, the Secretary of the Zonal Transplant Coordination Committee, Mumbai, Dr. Bharat Shah, who is also the Managing Trustee of the Narmada Kidney Foundation and Director, Institute of Renal Sciences at the Global Hospitals, Mumbai. Dr. Bharat Shah has been a pioneer jointly with Dr. S.K. Mathur and a few other seniors at Mumbai. Dr. Bharat Shah, over to you, sir.
Thank you, Parag, for involving me in this program. At the outset, I would like to echo the points made by Justice Sunil Amwani, where he brought out the point that our rules should be made less stringent. If we want our organ transplant program to progress, we have to make our rules less stringent and remove fear psychosis from the doctors. You may have read recently that doctors are being scared for asking a COVID test. And a municipal official said that tell us why your license should not be suspended for asking for COVID tests. Such fear psychosis should not be in the minds of the doctors, and doctors should be allowed to do their work. Now, in terms of improving our organ transplant program, the fact I feel is very important and can work at this time is recognizing more and more centers as non-transplant organ retrieval centers. You see, we have very stringent requirements for a center to perform transplant, which is fine. But you don't need very stringent criteria for a center to become an organ retrieval center, not performing transplant. And we should have many such centers in the periphery of the cities, in tier 2 cities, and they can be a great source of number of organs and can boost our program. Even if a center has been suspended for some reason for transplantation, if you have a suitable deceased donor, organ retrieval at least should be permitted. After all these organ retrieval centers are going to be under supervision of a registered center. And therefore, we should try and have as many organ retrieval centers as possible. And finally, yes, we should try and bring in a system which can increase more donations, and opt-in and opt-out system would be a system which we should consider. And I think the point of identifying next of kin to consent for donation is also an important point to consider. So these are the points I have.
Brilliant, sir. I think that's very summed up very well. Dr. Pandit, as they say on Doordarshan, व्यत्यय के लिए खेद है. Dr.
Yeah.
Pandit, over to you again, sir.
Yeah, so the second point which I was making is that once we have this universal definition of death in the birth and death register of Government of India, it would become easier for us to sign up certificates and basically not have any hesitation. The second would be if you have the permission to switch off the ventilator. Now, some people would interpret and say that their permission is not required because you're already declaring the patient dead. But reality is that all intensivists, all corporate hospital, all administrators are scared to do that. And some of us might take up the leap and do it because you can be dead only once, you can't die twice. But if we simplify that, and if that comes into the clear legislation that this needs to be done once you've declared the patient dead, I think the organ donation rates will automatically increase, because right now there's a hesitancy from people who they feel that if there is no consent or there is no indication that there may be a consent, they may not approach towards brain death at all. And the third and the last would be that in patients in whom we cannot do the apnea test, there should be some provision to diagnose death by circulatory category, which would be either a CT scan or a 4-vessel angiogram. But that should be strictly only and only if apnea test and the whole brain death testing is not possible for some reason. And there are various instances. Somebody who has a high cervical spine fracture, who is not able to breathe because of cervical spine fracture, we can't do an apnea test in him. Somebody who has got bilateral orbital fractures, we are not able to take the eye signs in them. And somebody may be hemodynamically unstable. I think if these three things are brought in, your organ donation automatically would improve, because you would have more and more people volunteering to basically go and diagnose brain death. And unless and until we accept this reality, it's not going to happen. That's it.
So gentlemen, I'm going to take a little pause here and try to kind of sum up. One of the things that's coming out very, very aggressively from practicing clinicians is the fact that there seems to be a fair amount of, I won't call it legal impediments, but I definitely will say that there are legal hurdles, so to speak, or ignorance probably of some parts of the law, or little inadequacies in the law which don't make it very clear as to how to proceed under circumstances. So probably a lot of clarity. And today we do have the lawmakers with us, we do have the parliamentarians with us, and we once again welcome them. We would like to see a little bit of this being spelled out. The other thing that comes out is on the entire decision-making process, as Dr. Bursani said, and Dr. Shroff also pointed out, who is going to decide? And again, we'll be coming back to the opt-in, opt-out discussion sometime later during this morning. We would like to know these things, and they should be clarified, because at the end of the day, we are wasting a lot of organs. We are not transplanting as many as required. The statistics are very clear. We are not able to transplant. I mean, the tip of the iceberg is even not getting covered. So to move on with today's deliberations, I'd like to call on Dr. Dhruv Chaudhary, who is the president of ISCCM. Dr. Chaudhary, namaskar. Welcome, sir. And
namaskar. Good to see all of you.
Over to you, sir, for some inputs on how we should proceed with organ donation and the law.
You see, I come from the public sector, and majority of you are coming all from dominantly from private sector. And unfortunately, after starting off organ transplantation in the public sector, like from PGI Chandigarh or from AIMS, gradually it has petered off. And very few centers are doing, when I look at Delhi itself, except for ILBS, if I take it up, where they are looking at liver and renal transplants, probably even PGI Chandigarh itself has not picked up beyond your kidney transplant. And Dr. Shroff has been trying with us at Rohtak itself, because we are facing a unique challenges in the government. And probably it's an elephant which walks at its own speed. I think that is something which we need to do it. So if we have to take the organ transplantation forward, the public sector has to come on board. And we have to see how we do it, because large number of patients who are coming to trauma, which we are talking about, are actually coming to public sectors. And from there, which can be a very big thing, we have been trying desperately. What I am finding the challenges are in terms of establishment at our places. First is, nobody is willing to own it up, unless or until somebody in the nephrology or this thing, they feel it's an additional burden. Now that is something we have to do it, and it's a very big barrier, one. Secondly, what we are looking at is that in this, besides ownership, infrastructure bottlenecks are also there. So they need to be put up too. Three, the government tends to be sometimes extremely self-righteous, and they come up the solutions which are far more difficult to implement. I think we need to, what is important, which I can understand looking at it, the places, is that we have to create a structure which are simple to implement, but yes, implementable and a very robust monitoring. Because I'm looking more from the perspective, because I have been asked to do inspections at certain places beside that our own center. And another thing which is, has been very rightly pointed out, is a brain death. Now the brain death we are finding is we go into looking at different committees, etc. I think now it has to be made a part and parcel of a curriculum of undergraduate and a postgraduate education across the board. People have no concept in the medical schools, and let's accept it. And we as the teachers are to be blamed about what is a brain death, because still they continue with the cardiopulmonary thing. And even because organ transplantation has not taken away, it is not discussed even that. So what we have started doing at ROPEC is that a final year when we are taking critical care classes, we are actually now trying to sensitize to them about what brain death is. I think these are small steps we keep on talking about, but I think it has to be in-house, which needs to be there. In addition to that, I think what is very important from this is that even if we don't have a donation centers because of the trained manpower, other things, or whatever may be there, organ retrieval centers needs to be stepped up, and they need to have some regional connectivities, like we are going to have a SOTO. For last 3 years, 2 years, Dr. Shroff is also listening. It took 2 years to set up a SOTO. I think we need to cut that. You need a political and medical leadership. These are the things which are extremely important. Tamil Nadu could do it because Madam Jayalalitha took on her, and she saw to it. It is implemented. I think somewhere we need a good and a strong political leadership along with the medical leadership, because these are the issues we put under the carpet. And your things will be as good or as bad as your leadership is. As you have seen yesterday, what was happening to the ICMR in terms of COVID trial. And in fact, our center is one of those, and we refused it. I said, patient safety is primary. I think what is important for us is leadership at the level of the government, facilitation at the level, putting brain death free, and fourth thing which is there, that we need to have more retrieval centers and a very close cooperation between public and private organizations. That's the only way forward. Otherwise, we will keep on coming in the circles discussing the same things.
I think, Dr. Chaudhary, you've put across your points very well. One of the things that's definitely should be on the cards, and I think we'll probably, not that I'd like to speak with any impunity, but I'd definitely like to table one thought, that there's a definite need to rehaul our medical education curriculum. We don't discuss quality, we don't discuss patient safety, we don't discuss organ transplant, we don't discuss patient rights and responsibilities. These are things which need to come in, and all of these will have an impact on the way clinicians look at organ donation as a holistic kind of a picture, rather than just teaching them about it, in their third year of Master of Surgery residency.
You see, 90% of the physicians in this country, I'm sorry to say it, have no concept about organ donation.
Absolutely.
Till they have it on their own. I think that is, for me, is the fundamental thing where I need to have a change. Rest things will flow.
So I think that's very well articulated, Dr. Chaudhary. Thank you very much for that. And I'd like to move on and welcome the Head of Department of Forensic Medicine at St. GS Medical College, a very premier institution of the country, Dr. Harish Pathak. I
don't think he has joined us yet.
Yeah, he's not joined us. I couldn't see him, but nonetheless, I called him up.
Yeah.
Doctor, I'd like to take Dr. Gracious Noble, please, who is the who runs the KNOS, that is a Kerala Network of Organ Support, Government Medical College. Over to you, sir.
Yeah, the biggest hindrance is already illustrated by Dr. Shroff. The main issue is death certification not happening in ICU if there is no organ donation. That is the biggest hindrance. So for this, Government of Kerala has issued an executive order in Jan 2020, telling that a properly certified brain death, that doctors are free to remove the ventilators even if the relatives object for removal. That is, you need not ventilate a dead patient. So that is very clear. But in spite of that executive order, none of the hospitals or none of the intensivists or none of the neurosurgeon has attempted to implement that order in at least part of that spirit. So we don't know why this is, whether there is a fear psychosis among doctors. The patient is dead to donate, but not dead to pull off the ventilator. That is what Dr. Shroff rightly put it. So this is the hindrance, and this is the only hindrance. Thank you.
Well, I think that's something which, first of all, we'd like to compliment the Kerala government for having done this, and all power to you, sir, that you're able to implement. At least the law is on your side on this particular point.
I just wanted to do the law. You make it up, but the people ultimately, the horse has to drink the water. Yeah. So that is very important. That is where the change is required.
The endeavor, sir, this is one step in, first of all, at many other states, we still have to find our horses and lead them to the water, and subsequently we'll make them drink the water as well. But I think we just have to go one step at a time. We are very grateful today that the lawmakers are also here. We will work on this. I'd like to invite the Zonal Transplant Coordination Committee President, Dr. S.K. Mathur, a teacher whom I respect and revere, a liver transplant surgeon himself. Dr. Mathur, over to you for your views, sir.
Good morning, everybody, and thanks for inviting me for this. I'll quickly make the point. First thing, somebody mentioned about the Tamil Nadu model. I think people should know about the Maharashtra was the first state to adopt the law and the amendments and issue the guidelines in 1999, way back that time. Okay. Now, suggestions from my side. One is regarding the brain death, which everybody is talking of the stop the ventilator. And what the novel was saying is right, that unless it comes as a part of the rules or the amendment in the Central Act, nobody will do it, even if the state government issues the guidelines or the SOPs or the GOs, because it has to be part of the Act. The ventilator should be switched off. That's one. Second thing is that certification of brain death. Right now, there are 4 people who are supposed to do the certification. Now, out of which, the first one, that is the RMP in charge of the hospital. Now, we know that RMP in charge of the hospital, not all are clinician, or even if they have been clinician, they are far away from the clinical practice. So, why to incorporate him? See, practically, he will not do any test. He can observe it, or sometimes he may not observe it. Practically, it happened that he signs it after everybody else is done. So why to keep him there? You need a primary physician in charge of the patient and one specialist. That's what the UK follows, Europe follows. You can have extra precaution. You can have one more specialist. So at the most 3 persons are more than enough. So the law has to be amended that we should not have 4 persons. RMP in charge of the hospital should be removed from that. Then next is the death that is after cardiocirculatory arrest, okay, cardiopulmonary arrest. Now, this is there in the Act, but the process to implement it is not there. So, the rules should be, in the rules, one should incorporate the process of certifying what is called the donation of cardiopulmonary death. And here, we won't have a 4 specialists, because cardiopulmonary death, as it is certified by 1 person. But here we can have 2 persons, the clinician in charge of the patient and the intensivist, who will certify that the cardiopulmonary death has happened, and there should be an SOP, as Sunil Shroff was also mentioning. We have some experience in KEM long back when there was no brain death and we wanted to do the transplant. This was 1990s, and we did implement a SOP for doing the transplant from the non-heart beating donor or donation after cardiac death. The other issue is what Rahul Pandit said, apnea not possible. Yes, we should have a provision for ancillary test, which is not there in the Act. It should be brought in. And recognition of the NTORCs. Yeah, make the process simpler. Now, as far as the identification of the brain death, some people said that there are brain death, but nobody certified them. Okay. So, though the law says that the RMP in charge of the hospital or the ICU intensivist should identify, should approach the family and everything, there is no way we can find out whether somebody is doing it or not. So, there should be in each state, there should be ICU death audit committee, which should be independent of the people who are doing the transplant or the government officials. and they should do the audit of all the ICU deaths and find out how many were brain death and why the people have not certified or family has not been approved for that. So these are my suggestions.
I think that's well articulated. I'd just like to move on and invite Dr. Swarnalata, who's been patiently waiting. Dr. Swarnalata represents Jeevandan from Telangana, from the NIMS. Dr. Swarnalata, over to you, ma'am. Dr. Swarnalata, please, you'll have to unmute yourself. Yes.
Good morning, everybody. So let me first thank the organizers for giving this opportunity. So I've been listening to the views put up by various participants. So I think can I share my slides before I start?
Yes, please. Yes, ma'am.
Yeah. So coming to today's topic, it's organ transplantation in India, legal issues and solutions. I think we can view this as a before and then after COVID pandemic era. And as you know, like it has come from a bad to worse situation. And as the saying goes, the fundamental rule of life is things were never so bad that they could not get worse. So we are actually in a state of worse now. It has come from a bad, and we have come to a stage of worse now. I just like you to go through our journey in organ transplantation in our state. So it's called Jeevandan. As you can see, we're doing fairly well. So we started in 2013 with 41 transplantation, and it has gradually increased till 2018. But if you look at today, I mean, this year's performance has been very bad. So we have only 37 donations this year from January, and total donations we had was 768. So if I again split that, we can see till March we were again doing fairly good. But once this COVID pandemic has expanded, and then we had more and more people turning positive, this transplant program has come down. We hardly had 9 donation in last 3 months, and of course you can see the May was absolutely no donation at all. So it has drastically come down from almost 10 to 25% of the donations. And I believe most of the states, they have the same situation. So as it has been discussed, like, before this, the pandemic, there were a lot of legal challenges, right from the, defining the brain death, and the how many number of people should be there in the panel to define the brain death, and then whether is it mandated to declare a brain death, or we have a right to switch off the ventilator once patient is brain dead. So I think this Kerala government and then the Gujarat government has come way forward, and coming up with a geo stating that it's mandatory, and once it is brain dead they can remove the ventilator. But I think Gujarat is the geo, if you read the geo, it's still harsher than the Kerala. They say it can be, the moment patient is brain dead, you have to go with the declaration of the brain dead, which is mandatory. And if they say no, all the ventilators can be switched off, and there is no need to support the patients. Later, the words which have been used is still harsher. But I don't know how much is being implemented. But then now we see another problem coming up. So, and then as has been rightly pointed out by one of the participants, that I come from a public hospital, that is NIMS hospital. I'm a nephrologist there. So we see a lot of challenges in government hospital, because you forget about identifying a patient. We have so much of shortage of resources that we don't have ventilators, we don't have ICU beds, we can't take the patients in, particularly the trauma patients. And we have a deficiency in terms of the manpower, the one neurologist will be there looking after the entire hospital and load. So we have a lot of issues at every level, right from the infrastructure, manpower, the policy making, the administration, coordination by the administration, everything. So this is what being from a public sector, I think there should be special, laws like, enabling these public sector to take up the organ transplantation program. So at this stage, what I see is we have newer, legal challenges and clinical challenges with respect to the COVID as well. So as you know, the COVID testing is important for the donor and the recipient, which is not rightly available to most of the hospital. And there can be like chances that it can be negative. And then post transplant, once they get exposed to them, and they can always, you know, question the transplantation team. So these are the things we should look into. And another thing is, now I have heard from my own colleagues that no, the patients are asking for the COVID status of the even the healthcare workers. So, like, you know, they can have a right and they can challenge if it's not available, and how frequently it should be done, because particularly we are doing a transplant. So these are the newer legal challenges I foresee in this era particularly. And I don't know how long it's going to be there. It's very unpredictable. And as you know, most of the transplantation program, not only in our state, in India and across the world, it has come down. And we are actually having a shortage of all ICU beds, which was, I mean, like, you know, previously also it was there, but now we have more challenges with respect to ICU beds and ventilators. And I think these are the new challenges which I see in particular this era, particularly where we have been doing fairly well, and now I see, like, you know, sudden fall in the transplantation, new challenges coming up, and then how to cope up these challenges. So I think these are the certain issues apart from the regular which I've been talking about, these should be, you know, taken into consideration and this particular time. So we need not stop completely transplantation program here, but we do have certain, you know, solutions, like as with respect to, you know, I think we will discuss about various issues which have been there and which will continue to be there. And these are specific issues with respect to the COVID, because again, can we go ahead without a COVID testing, and how legally we are protected even, if you go do a transplant without the availability of the testing, and how the hospital, you know, can gear up, despite having a COVID-free pathway, and despite, you know, allotting the resources for this COVID-free pathway and then the transplantation. So I think these are the, you know, future solutions. And then, you know, like what should be the informed consent with respect to particularly taking up these challenges. So I think these are the things which we should concentrate, apart from what we have been discussing, the regular challenges which have been there for decades and which will continue to be there. So these are the new challenges, I think, which should be, you know, looked into. Thank you.
Thank you, Dr. Swarnalata. I think I remember 3 words in Latin which were taught to me by my professors where I studied: primum non nocere. As long as you commit as doctors to do no harm, I think we have to find a way out wherein we are doing no harm to both the, you know, to the recipient, to the recipient's family, because as you know, COVID is a complex disease. So thank you so much for that. I think it was very crisp. I would like to now invite the authority in this matter, Dr. Vasanthi Ramesh, who is the director of NOTO. Dr. Vasanthi Ramesh, over to you, ma'am. Ma'am, your mic needs to be unmuted, please.
Extreme left.
No, yeah, that's it. Thank you, doctor. Dr. Vasanthi, you're on and you're live. Ma'am, we can't hear you. Ma'am, we can't hear you. No, ma'am, you're not audible.
She has not muted herself.
Ravindra, can you call her personally and just get this organized, please? Yeah. One of the things that I'd like to just say that, which is, I think, the lessons we learned from everybody. Dr. Swarnalata, what we've done in Bombay, at least, is that we have neurologists whom the ZTCC requests to go across to institutions where there is no neurologist or there is no support for brain death. So that's something which we've learned, helping each other out, because at the end of the day, the number of organs retrieved in the city is our benchmark for success. We need to keep on increasing that. So you can also probably work in a public-private partnership kind of a way to help each other out, because you need a neurologist who's accredited by the ZTCC and who's registered with the Department of Health Services. So you can work on that also, ma'am. Dr. Vasanti, can we hear? Am
I audible now?
Yes, you're audible now. Please go ahead, ma'am. Welcome, ma'am, and please go ahead.
I would like to thank Dr. Ravindra Mangal and Dr. Parag for giving me this opportunity, and particularly for giving me the last word in this session.
It's not audible.
Audible? Again, I'm muted.
लेकिन अभी वापस आप निकल गए हैं इसमें से.
I'm muted by you from your end.
Ma'am, you're audible. Please go on. Please go ahead. Can everybody else please mute their mics?
Yeah, I'll do that. Okay. So, as very rightly summarized beautifully by Honorable Justice Ambani, we know the sequence as to how the Act was passed in the Parliament, the rules were formed and they were amended subsequently. I would like to touch upon points that have not been touched upon by others earlier, particularly because NATO is the national organization which links the country with the international organizations and with other countries of the world. And why is it NATO was at all set up? So the main issue in transplants, other than the paucity of organs and other things, is that it was tainted very badly by the transplant commercialism. So in 1987, the WHO first prohibited transplant commercialism, claiming that such trade is inconsistent with the most basic human values, and also that it contravenes the Universal Declaration of Human Rights. So they formed a guiding principles for human cell tissue and organ transplantation in 1991, where they said organs should be donated freely without any monetary payment or other reward of monetary value. And this was in the WHO World Health Assembly 4425. Then the United Nations also said in its Convention Against Transnational Organized Crime in 2000 that trafficking in human organs is a cause for human trafficking itself in its supplementary protocol. Then came the Declaration of Istanbul in 2008, where they defined transplant commercialism, transplant tourism and organ trafficking. So they defined transplant commercialism as a policy or practice in which an organ is treated as a commodity, including by being bought or sold or used for material gain. So transplant commercialism is now prohibited in most national jurisdictions, including ours, and that is why TOA came into being. Then in the WHA 6322, though the Act was there for a length of time in many countries, still transplant commercialism was going on, organ trafficking was going on. So it called for an agency to be created which should be in charge of the coordination and oversight of donation, procurement and transplantation activities at the national level. So to achieve this, NATO was created by the Act, the Transplantation of Human Organs and Tissues Act, which was the amended Act in 2011. Then it is important to note that the UN General Assembly also passed a resolution in 2017, Resolution 71/322, which aimed to strengthen and promote effective measures for international cooperation on organ donation and transplantation, thereby preventing and combating organ trafficking in persons for the purpose of organ removal and also trafficking in human organs. So what were the requirements for prosecution which they laid out in this 2017 meeting? They said that international guidelines have to be developed on health, criminal and human rights, and WHO guiding principles of transplantation are violated by these acts, and therefore cooperation and adequate training both of the authorities and the healthcare specialists as also the state security forces and bodies ought to be taken up. Then the resolution, mainly the points were that the resolution was meant to help prevent and combat two forms of criminal activity. That is trafficking in persons for the purpose of organ removal and trafficking in human organs. So to address these aspects of the crimes, human rights, healthcare and the criminal aspects, all three aspects, the resolution was passed. And what was the need for all this? Plus the TOA and its Amendment Act in our country, the most important thing is the dismal deceased organ donation rate, which is a mere 0.65 per million population in our country. In contrast to the total donations, where we stand only next to the USA, but a large part of it is from living donations, which again is associated with a lot of issues where it is claimed that there is a lot of organ trafficking and false documentations, etc. So therefore, these are points which I would like to dwell. One is how we can, being a signatory of the World Health Assembly, how can we be a responsible member state by implementing all the WHO guided principles. Number two, as earlier said, that medical students are not taught. Action has been taken in that direction. The MCI in its 2018 review has included the topic of organ donation and transplantation as well as brain death in its curriculum for both undergraduates and postgraduates, and we hope that it will bear results in 5 to 6 years time from now. Then the third point is public sector has to come up, as raised by Dr. Chaudhary. It is very important. Unless and until the public sector hospitals declare brain death, and there I would also involve the private sector, because the maximum transplants are done in the private sector, but brain death declarations are not done, except maybe in the state of Maharashtra and to some extent in Tamil Nadu, but still not matching up. So that is another important thing. Then the other thing is the media should be apprised, educated on organ donation and transplantation and the legal issues, so that their coverage is, based on knowledge and not reactive like how a lay public would do so. So also when media reports, it is important that people who have been in official positions, see, it is demeaning the country if national organizations and state organizations are not given the pride of place, because these organizations belong to each and every one of us. It does not belong to the person who sits in any chair. The person only does whatever he or she does on behalf of the 1.3 billion population, like how the Prime Minister represents the country. And therefore, everyone should consider it as their organization, particularly the transplant professionals, and cooperate and strengthen the national, regional and state level organizations, comply with the laws which mandate that there should be a web-based interface with which all these Roto, Soto and Noto can have the data simultaneously online, and so data should be uploaded online on the Noto portal, so that it is visible right from Noto up to the hospital level in a single shot. So with this, I put the thing to rest so that we can go up for further discussions. Thank you very much.
Thank you. The way I'm an NEBH auditor, and we look at things in a very structure, process, outcome way. To look at the structure of today's discussion, we've essentially heard the doctors. We'd like to hear from the lawyer now. I'd like to invite Advocate Mahendra Bajpai, advocate who's an advocate at the Supreme Court of India, Editor Emeritus Medical Law Cases for Doctors, and Honorary Director of the Institute of Medicine and Law, and I think for me very important, a very good friend and an excellent orator. Over to you, Advocate Bajpai. Thank you very much.
Dr. Harish Pathak has joined in. Let
Oh,
the
excellent.
doctors finish, then the advocates will take up, if you don't mind.
So gracious of the advocates to yield the floor, sir. Thank you very much. I request Dr. Harish Pathak, who is the head forensic medicine at the St. G.S. Medical College. Sir, over to you for your views on the legal challenges in legal and other challenges in organ transplant today. Dr. Pathak, please.
Can you hear me?
Yes, sir.
Thank you. There were two issues on which we had a lot of deliberations, and two legal issues which the hospitals are facing. Number one was that in the recent amendments, the law says that you had to intimate the death to the police officer or the investigating officer. Earlier rules were that you had to take permission of the investigating officer for the retrieval of organ. Now, permission versus intimation was an issue, and we went up to the DG, and we even met the legal advisor to DG, but somehow nothing came in writing, and there is still confusion, wherein they say whether you have to intimate the investigating officer or you have to take his permission before retrieval of organ. Now, what has happened, there was a case in New Mumbai wherein I think all of us know that when the hospital sought permission from the investigating officer, he comes and tells the relatives, the next of kin of the donor, potential donor, that why you are donating, you know they make tons of money, don't do this. And somehow it could not be done. There was a lot of hue and cry. So we need to have a clarification. If the law says that it is information, then it is information. That was one thing. And we need to have in black and white that you don't, because most of the vast majority of donors, they have head injury, they are cases of vehicular accidents. If you go to US, most of the Western Europe, many times they don't even conduct autopsies. Here, cause of death, manner of death, everything is, identity is clear. So we just intimate them and the organs are retrieved. So that if that is clarified, that would be great, because law itself says that you have to intimate the investigating officer, not take his permission. But there is still ambiguity on that. Second part was that most of the recipients, they are in corporate hospitals. We have seen that. And many deaths, most of the deaths are happening in the hospitals who are not the recognized autopsy centers. Now, what happens that a patient is declared dead and brain dead, we retrieve the organ, and subsequently, police will do Panchanama, body will be shifted to the autopsy center, and it takes up to 24 hours and lot of harassment for the next of kin. So what was decided was that, and it is also one of the recommendations, that the hospital should provide a side room next to OT from where the organs have been retrieved, wherein an autopsy team can go inspect the dead body. If required, they will do because they have already opened chest and abdomen. Only if required, we may open the head, and then and there we hand over the body, so that this, lot of delay in handing over the body and medico-legal hassles will be avoided. So we had decided here in the Roto Soto, headquarters is for Western India is in KM, that we will form a team. We will recognize the teams in all the districts, all the major places. The question came that who will pay for the team to go to those corporate hospitals or other hospitals and do these things. For one autopsy surgeon and maybe 2 servants will be required. So it was decided, but somehow we could not conclude, or it has not been implemented. So these two issues, I think we need to sort out, which will really help in, improving the rate of organ donation as well as hassle-free organ donation. Thank you.
Thank you so much, Dr. Pathak. And As we can see, there seem to be 3 or 4 very germane issues arising out of from the doctor's side. And may I request Advocate Mahendra Kumar Bajpai, who is who's an advocate at the Supreme Court, Editor Emeritus for Medical Law Cases for Doctors, and Honorary Director of Institute of Medicine and Law, to kindly take center stage and opine on some of these issues and what are the solutions and other issues that may be coming up. Advocate Bajpai.
Thank you, Dr. Rindani. Dear friends, I do agree with what most of the panelists have said. The nation today needs a central law on uniform determination of death. Even the World Health Organization has recommended so. Many of the countries are following this uniform determination of death. But a central law is required. We have already heard from Dr. Noble what has happened with the Kerala experiment. Number 2, as far as hierarchy in surrogacy is concerned, it is required. But then we have a problem in India. And the problem, I'll share with you the legal problem, is that we don't have a uniform civil code. Every religion, every region has its own hierarchy of relatives. We have the Hindu law, we have the Muslim law, we have the general laws. So bringing in something like this would be a Herculean task. Nevertheless, if we can bring it only for the limited purpose of transplantation of organs and nothing like that, that will help. In fact, this is a problem not only faced in transplantation, but even by general hospitals. The brother and the father, they are fighting. The wife and the father-in-law, they are fighting. And the hospital administrator has to take a call. As far as end-of-life care is concerned, I would just want to make things very clear. The Supreme Court of India has given a judgment in common causes cases where they have prescribed a very elaborate procedure for giving advance medical directive for switching off the ventilator. And the Honorable Supreme Court has said that the procedure that we have put down is only a stopgap arrangement. We feel that a law on this aspect is required. And we request the legislature to come up with a law. So friends, it is very easy right now to say that yes, let us give us permission to switch off the ventilator. That permission has to come from the Parliament of India after deliberations. One suggestion which did come, I endorse it. There should be compulsion to identify brain stem death. Some changes in rules can be made. We don't need a law-making body to make law. Say for every 72 hours or every 4 days, the intensivist in charge should certify that the person is not brainstem death. 2 important non-legal aspects. 1, we all agree that procedure has to be made simple and monitoring has to be robust. But let us again understand, because of the bad name that is attached with the organ donation, but you know, every doctor, every hospital is trying to play safe. So it is the responsibility of statutory bodies like Noto, Roto to create proper awareness. And yes, I do agree, more awareness is required with media. They have to be informed. Your headlines which you try to splash out from transplants and those rackets that you try to make out, they are causing a big harm to many people who are waiting for organ donation. That is all, Parag. Thank you.
Thank you, Advocate Bajpai. We've heard the doctors and the legal side also, and I'd like to now invite Dr. Ratna Devi. She is the voice of the patient. She is the voice of the end consumer. She is currently the chair of the International Alliance of Patient Organization, which is a charity based out of UK. She's also the founder of Indian Alliance of Patient Groups and the founder board member of NCD Alliance in India. Dr. Ratna Devi, over to you, and thank you very much for being there. It's pretty late. Please, over to you, Doctor.
Thank you, Dr. Randani, and thank you to the organizers for inviting me to this forum. Though I am a qualified medical practitioner, I'm bringing the patient voice here, and that is the uniqueness, to this whole forum, because we've been hearing a lot from all the practitioners, the legal practitioners, as well as the policymakers, but the patient voice is usually very, sidelined or not heard. We've heard about the legal challenges for declaring brainstem death, but I think beyond just the legal part of it, there has to be an environmental change in terms of what organ donation means and why it is important to people. Considering the public health, challenge of having the largest number of people suffering from non-communicable diseases in India. So if we see the number of people who will actually require organs in the next 10 years or so, it's going to be phenomenal. And unless we prepare for it, I don't see how we are ever going to manage that demand. So there is a fear psychosis amongst the doctors, and there is an equal amount of fear psychosis amongst the patients as well as the next of kin of donors. And as Advocate Bajpai pointed out, I think there has to be a clear communication strategy that not only involves the media, the policymakers and the healthcare providers, but also the general public about decriminalizing the whole issue of organ donation. I think there is also a need to recognize a formal patient body. At present, nothing exists, but if there could be a patient body that could consist of both the donors or the next of kin of donors as well as the recipients, who are not only dispelling the myths and misconceptions that exist around organ donation, but also help the new people navigate the system by providing the right kind of information, provide counseling services, share positive donor stories, and have a part of, sort of channelizing the non-monetary rewards and recognition program in partnership with, of course, the policymakers and the hospitals. It would, create a positive environment for organ donation in India. And last but not the least, I don't think it should be restricted to just the health department or the Ministry of Health, but there has to be some method or mechanism for multi-sectoral coordination, because this also involves not only just the health department, but also the police department, other security agencies, roads and transport, everything. And then there is a registry mechanism for the donations, but there is no registry for hospitals that are qualified to either do a donation, do a transplant mechanism or to do a retrieval mechanism. And if a common man wants to know this, there is no central repository which they can refer to. So if there could be a central repository which a common man can refer to in terms of where to go to, both for the knowledge as well as for the donation, that would be a great, helpful mechanism in place. Thank you.
Thank you, Dr. Ratna. I think the voice of the patient has been heard, and we shall definitely try to work on it as we go ahead. I'd like to take, I think it's time always to learn from what other countries are doing and what other people are doing. So with everybody's permission, we'd like to move ahead, and I don't see Dr. Baliga having joined us. No. Okay. I'd like to invite Dr. Ajit Tennakun, who is joining us from Sri Lanka. Dr. Ajit, welcome. He's a forensic specialist and he's the Chief Judicial Medical Officer of the Department of Forensic Medicine, Institute of Forensic Medicine and Toxicology at Sri Lanka. Neighbors we are, and let's see what we can learn from each other. Dr. Ajit, what do you've been hearing us patiently for the last hour. We are a complex nation, and what can we learn and pick up from Sri Lanka? Please, sir, please go ahead.
Ayubowan and regards from Sri Lanka. And first of all, let me thank the organizers for inviting me, and very interesting discussion. In fact, we also had these problems, and actually, I in outset I would say that with various legislations and the circulars issued by the Ministry of Health and the Ministry of Justice, we managed to improve our deceased donor transplantations. If you take the statistics from 2011-12 to where we didn't have any even single deceased donor transplantation. Now in 2014 we had 84 renal transplantations and 7 liver transplantation, disease transplantation. So actually we are governed by the legislation, that is the Transplantation of Human Tissue Act, enacted in 1987, where the death is defined properly and how to determine the death is being defined, and also when the death actually defined as the irreversible cessation of the function of the brain, and then the prolonged cessation of respiratory and cardiac function is how to diagnose the brain death. And also when the brain death is diagnosis of brain death is impossible with the artificial means, then how to diagnose the brain death with the available ordinary medical standards. So the professional colleges of anesthesiologists and intensivists came up with the guidelines to diagnose the brain death. Actually, the main problem that we had with this legislation that it has defined and described all these things, but one clause says that nothing in this act will apply on the deaths where it will be subjected to an inquest to find out the cause of death and the manner of death. So to overcome this issue, actually most of the suitable donors are from this category. So to overcome this, actually with the Ministry of Health and the Ministry of Justice, with the collaboration with the Attorney General, came up with circulars issuing when there's a suitable donor. In fact, first of all, the National Transplant Coordinator has been appointed from the Ministry of Health, and all the institution has been appointed institutional transplantation coordinators. So their duty is to coordinate with all these logistic problems, and when there's suitable donor, the coroner or the inquiry into sudden death is called in our country. The coroner has been informed through the police to get the formal approval, and also the judicial medical officer, the forensic pathologist who will be doing the autopsy later, also been informed, and if necessary he can attend the transplantation, the harvesting surgery to observe the injuries and the condition of the organs, and subsequently he will do the autopsy in his the morgue, so then he will complete the report of the autopsy and submit to the coroner. So this is how we overcome these issues. But still like the some of the questions that you raised in the discussion, like the reluctance of the clinicians to diagnose the brain death, and also the switch off the machines are still there. And also we recently we issued the circular from the Ministry of Health advising how to overcome these issues. Within 24 hours, if the medico-legal clearance is not given after diagnosing the brain death, the switch off the ventilator. And if the medico-legal cover is given and there's a delay in harvesting organs, of course they can wait. But at least, but like this, the Ministry of Health has given most coverage, legal and other coverage, of course, with the agreement with the Attorney General for these issues, legal issues. So I think in Sri Lanka we have remarkably achieved some improvement in disease donor transplantation with these legislations and the subsequent circulars issued by the Ministry of Health, Ministry of Justice, and the Attorney General Department. Thank you.
Seems to be a very concerted, collaborative approach between all the legal authorities, including the police, as well as the medical professionals, which we've seen a lot of success on that also. Still, we have some way to go. So thank you very much, Dr. Ajit, for that very crisp discussion. I'd like to hand over the microphone and invite Dr. Joseph Palmero, who is the chief of the Medico-legal division at the Philippine National Police. Dr. Palmero, how are you succeeding in the Philippines? I mean, These are complex issues across all geographies. And what are the factors that have helped you to make this a success in your country? And what are the challenges that even today exist?
Good morning,
Sir.
everyone, and from the Philippines. Thank you for inviting me in your convention. In the Philippines, as an introduction, the Organ Donation Act in the Philippines was enacted into law in 1991, and based on this law, there is a concrete definition of death, legally defined and classified as circulatory death and brain death. And from this law, the organ and tissue donation from donors who have been declared dead has been allowed. Unfortunately, despite our law, donation from brain dead patient remains dismally low in the Philippines. This statement is coming from our Department of Health. And even there is a single and uniform definition of death in the Philippines, it did not help increase the deceased organ donation in my country. To give you the figures regarding organ donation rate from cadaver donor, in 2005, data revealed that there is only 0.1 per million. And in 2016, there is 0.5 per million. That is roughly around 20 retrievals per year from cadaver donors. Compared to Singapore, the organ donation rate from cadaver donor is 4.7 per million. And in Western country, it's 10 to 30 million. With regards to the living organ donation, in 2003, there are around 420 kidney transplants conducted in the Philippines. And in 2008, there were 800 foreigners, mostly from Middle East and Japan, had kidney transplant, meaning there are more foreigners getting kidneys than Filipinos. And that prompted our government to enact a law against organ trafficking because of this commercialization of organ transplantation. And from then on, the transplant rate is decreasing because our Department of Health is now discouraging incentivized organ donation between donor and non-related recipient. In 2013, there are 363 kidney transplants. And currently, it has decreased even more and averages around 250 kidney transplant per year, and 90% of which is from living donor. So our laws don't hinder organ donation, but they don't encourage it enough either. With regards to the corneal transplant, corneal transplantation in the Philippines. In the Philippines, the forensic autopsies are being conducted by medico-legal officers from Philippine National Police. And we have an iBank Foundation of the Philippines, which is a non-profit private humanitarian organization. And they had a memorandum of agreement with the Philippine National Police for the retrieval of corneas from cadavers. The iBank technician goes on duty with the forensic pathologist in the police. And during autopsy and with the consent from the family, the iBank technician removes the cornea prior to autopsy. If the next of kin is not available, the law, the organ donation law in the Philippines, allows the hospital director and the forensic pathologist to give consent for corneal removal. Since the iBank started in operation in 1995, they already conducted 20,000 plus corneal harvests in the Philippines. And for the last 5 years, the iBank harvested 4,434 corneas. The average is around 800 corneas a year and mostly from forensic autopsies. It is the policy of the iBank not to give financial reward to the next of kin of corneal donor. However, they give certificate of appreciation for the family and wreath of flowers for the dead. Another question for me here is, how does your country have a specific mechanism that is helping increase organ donation in these cases? The Department of Health in the Philippines has created the Philippine Network for Organ Sharing. It is a central coordinating body for all organ donation and transplantation activities. For example, if you need a kidney, so you will have to register in the Philippine Network for Organ Sharing, and that office will look for a kidney donor. At the moment, there is a pending bill in our Senate for the opt-out system in organ donation. In the law of organ donation in the Philippines, there is a required autopsy in cases of homicides or accidents. However, it's not mandatory. So for cadaver donors in general, autopsy is not required as long as the attending physician has already signed the death certificate. However, if it's a death due to homicide, autopsy is still required. So thank you.
Thank you, Dr. Palmero. I now would like to invite Dr. Maria Paula Gomez, who is the Executive Director of the DTI Foundation, Parc Científic de Barcelona from Barcelona, Spain. Dr. Maria, you've been patiently waiting. Over to you, Dr. Maria. Please go ahead.
Thank you very much, and good morning, everyone. Namaskar. Thank you, Dr. Rindani and the Institute of Medicine and Law for inviting me to this very interesting discussion and debate. And let me congratulate all of you and congratulate India. I really believe that you are in the right pathway, and this type of discussion and this type of debate are very helpful for the implementation to a right model of disease donation and transplantation in India. I will share a few slides about what I want to comment to you today. So hold on, if I can do this. Can you see my slides now?
Yes, ma'am.
Okay, so that I want to point out regarding organ transplantation in India, legal issues and solution, is if we want to talk about transplant and how to improve organ transplantation in India, we have to talk about organ donation and disease organ donation. And then the majority of the people here today should be familiar with this pathway. No? The things that you are seeing in the screen is the disease organ donation pathway that happen inside of a hospital, any hospital in the world, I will say. So disease organ donation is a hospital process, and then the solutions to improve or to improve organ donation should be focused inside of a hospital. Any action or any strategy that is needed to implement to improve transplantation and organ donation should be think to do inside of a hospital. And then, as probably Dr. Rindani, you mentioned at the beginning, we will not invent the wheel. There is very well known about leading practice in organ donation, and then this is the list of things to do. No? So the first thing is we need in-hospital organ procurement units. What is this? We are talking about that organ donation is a hospital service. Right now, in some regions, organ donation is considered only after death of the patient or only as something add to a transplant service, and this is not the case. Organ donation is a hospital service itself for any care center. The next leading practice is we need a specialist dedicated to organ donation, to disease organ donation. That's something that we call transplant procurement managers, or we can call key donation person. And then this is a very specific role and profile of this specialist. It should be a doctor, a medical doctor. It should be ideally a doctor from the intensive care unit or from the emergency department. And there is a very well description who should be this person specialized in disease organ donation. Network, it should not be organ donation, disease organ donation and transplantation cannot work in isolated way. So is needed a national system with a regional and transplant, regional and national organization with transparency for all the data and the rules that have been implemented in the system. Knowledge, of course, to the healthcare professionals, to the community as well. But when I heard that you develop some laws, but then unfortunately nobody follow. This is not because of lack of law, it's because of lack of training, education and knowledge about the new rules or the new guidelines that have been created. Budget, of course, disease organ donation should be considered as a new healthcare specialty. So for this new specialist, this is a job. and a career pathway should be developed for all of these group of professionals. And lastly is the communication with the society. So it's educate the society, but this is not about mass media campaign, donor registry, driver licensing. It doesn't work. It doesn't work. So it's about to inform periodically to the community about the importance of transplantation and the importance of organ donation. I bring more slides. I will go very quick about this. This is Spain. I will not talk about the numbers because I believe you already know Spain is with the highest rate in disease organ donation. But I bring this is because here you can see the different strategies that I already mentioned to you were implemented across the time of the implementation of the Spanish model in organ donation. A group of the donor coordinator is a group of these specialized professionals dedicated to organ donation, the involvement of the intensive care doctor, the training of the healthcare professionals since the very beginning in 1989, and then many other options, many other strategies that have been implemented across the time. This is, of course, is not about economic issues. It's not about religions. And then you talk about opt-in and opt-out. And this figure that wants to compare in the left, you will see the countries in blue with opt-out and in green with opt-in. And in the right side, you will see the disease, the organ transplantation rate. So you will see that there is not a correlation. There are studies about that. There is not a correlation between the countries who has an opt-out and highest donation rate or opt-in and lowest donation rate. Currently there are countries with opt-in legislation and they have a very good donation rate. So it's not about to changing the law in this regard. And this is to point out regarding driver licensing or mass media campaign. This is a study in Europe called Eurobarometer that we can see here the percentage of willingness to donate in the different European countries, and we have also Australia here, and then the donation rate. And there is not a correlation between the willingness of the population to donate and highest donation rate. So we have here, for example, Sweden with the highest willingness of donation, but with a very low donation rate. So just to give you one example, but we can see many other countries in similar situation. So this is the last study that I want to bring today, and this is about the hospital attitude from the critical care staff towards organ donation. And there is a correlation, a direct correlation, as much as positive attitude and good knowledge regarding disease organ donation and transplantation within the healthcare professional, mainly ICU staff, the donation rate will be higher. I think that, well, this is donation rate 2019. So as we mentioned before, I guess some of the speakers mentioned, India is here near with 0.69 donors per million of population, and the challenge, and it's possible, is to bring India to the highest rate in disease organ donation in the world. And that is all that I want to share to you today.
Thank you, Dr. Gomez. Thank you very much. And with that overall oversight of what's happening across the world and in India, it's my privilege and honor to invite Dr. Bhagwat Karad. Dr. Bhagwat Karad currently serves as a member of parliament in the Rajya Sabha, which is the upper house in the Indian National Parliament. But I think it's extremely germane here to say that Dr. Karad is also an MCH in pediatric surgery. He is a surgeon, a practicing surgeon also. Over to Dr. Karad, sir. It's an honor to hear you speak, sir. Sir.
Good morning, everybody. First of all, I thank Mr. Ravindra Mangal and Mr. Parag to organize such a national convention. And it is very much essential to save the life of the people who are in need of the solid organs in donation form. And one thing I have noted, Mr. Mangal and Mr. Parag has involved everybody. Means they have involved the experts in the medical faculty, They are expert in the law faculty, as well as somebody from the patient side, and some from the other part of the other countries also. Actually, I am a doctor. I am a pediatric surgeon, as Mr. Parag has said, and I was in political activity at the state level. But recently, the, our party has given me chance to work at the national level and to make such laws that Lok Sabha and Rajya Sabha are important, and I am sure that such a discussion is very much important because the laws are made in the parliament, that is true, but the expertise lies in the periphery or in the country. So this is the real team what I feel. There you can guide us and you can give the conclusion whatever is about the panel discussion. Mr. Mangal will forward to me, and I will promise everybody that something will come out of this discussion, and I will see that this question will be raised in the Rajya Sabha, and not only in Rajya Sabha but in Lok Sabha, and we will come to some conclusions. I was reading 2 days back regarding organ transplant, and in India itself there are 1,75,000 patients of kidney and around 1 lakh patients of liver are waiting for the donations. Means they are in need of the organs. Not only that, there are number of deaths. If you see, there are 17 deaths per hour and around per hour death in India, but there are no facilities to resuscitate the death and to transfer the injured body to a good hospital where the organ can be taken out and the donation can be done. That are the difficulties in our country. But in any way, something I want to discuss with you. Just I was reading because I am unaware of this field. Although I am a doctor, I am a pediatric surgeon, not concerned with the organ transplant. But here in the hospitals, there are less number of transport coordinators. The role of transport coordinators and the ICU people is to convince the relatives. And I think here we lack in such convincing the relatives to donate the organ. That's what I want to say. Then I was reading, and in that I read that postmortem, can the postmortem be done at the private hospital? That was one point, and that I clicked. If the hospital postmortem of such patients which are injured and where the donation is possible, is they are doing in all the government hospitals. But if it is possible, then that can be done in the private hospitals. And as Mr. Maria said, there is a infrastructural problems in our country. If you see the budget of our country, the highest budget in our health is in US, that is around 19.3%. New Zealand is 18.4%. Germany is 17%. But in India, it is only 3%. So we have to develop the infrastructure also. Unless and until the infrastructure is developed, I think this problem will not be solved. As rightly somebody, I think Mr. Patak or somebody told that there must be corporate hospitals are doing the transplant, and the public hospitals are patients are admitted. So if these two patients, means the donor and recipients, are in the same hospital, that will be helpful. So certain points which I want to inform that in Rajya Sabha or Lok Sabha, whatever the inputs you give, that will present, and naturally that will be helpful for our knowledge also. There will be discussion, and after discussions we will come to the certain conclusion. Definitely this is a very important discussion. It is not concerned with any party or any ruling things, but it is concerned with the living people or living peoples. So my request, Mr. Mangal and Mr. Parag, is to send a document after this panel discussion to me, and I will definitely see that certain fruitful things will come out of this panel discussion, and you will see the result in Rajya Sabha, as well as I will give it to Lok Sabha also to my friends, and will come with the positive things. Thank you.
Thank you so much, Dr. Karad. Really appreciate it. Before I move forward to 15 to 20-second rapid fire for each participant, I'd like to invite Justice Sunil Ambani ji to kindly, he wanted to add a particular pertinent point. Justice Ambani ji, over to you, sir.
Thank you. Thank you very much. Can you hear me?
Yes, sir. Yes, sir.
It's a very interesting discussion. I'm still looking for the rapid fire. But there's one suggestion I want to put after hearing all that. The doctors are under unnecessary fear. The fear psychosis is the point out. I want special mention to Dr. Karad. Why can't we have an overarching legislation, just like judicial officers, legislation for good faith? Any advice given by a doctor, any surgery or procedure performed should be taken in good faith. The doctor should not be called in question unless and until there is any complaint against him or there is a breach of reasonable care. That overarching legislation protects the judicial officers. Yes. Also protect the doctors. The second thing which I want to say is the surrogate hierarchy, the matter can be referred to the DGC civil, who can put up before the court, because court is the ward and guardian of everyone. You can put up before the district judge if there is any dispute about the heirs. The third thing that I want to say is the brain death definitely requires a very clear definition, and a definition should come in this Human Transplants Act. So far as the accidents are concerned, there is no need to go for a postmortem unless there is any complaint of any. Every accident cannot be treated as a homicide because unless there is a complaint. So in that way, we will have thousands of people. It's a great human right issue. It's one side is a human right issue is trafficking. On the other side is those thousands who are waiting for their turn for human. Now, these are my suggestions. Thank you.
Thank you very much, Justice Ambani ji. Quickly over to each one of you. I'm going to start with the people who are on the screen. 15 seconds, a few words of what you think has been discussed. What would be your top suggestion in terms of things to do? I'll start with Dr. Noble Gracious. Sir, I can't hear you. Sir, please unmute yourself. Words of pearls of wisdom. Yes, sir.
One is death, either brain death or circulatory death, and doctor is permitted to terminate the care by all means. That's all my.
Yeah, Dr. Mathur.
Yeah. So, one, amendment to the Act, remove the RMP from the brain death certification, include the ancillary test for BSG certification. Second, additional rules to be modified, which doesn't have to go to the Parliament. That is, the DCD certification process should be set in. BSG removal of the ventilation, what has been pointed out, that should be brought in. PM SOP should be set up. NTORC certification SOP should be set up, which should be simplified. Audit of all ICU deaths, there should be a SOP for that. Public hospital participation is important. Each state should identify premier institute and create an institute of multi-organ transplantation in collaboration with the public-private partnership, which will also improve the organ donation, and create a department of intensivists in each hospital for training, and that will help in maintenance of the donors also. Thank you.
Dr. Shroff, sir.
Yeah, thank you. I think most of the people have really dwelled on exactly what we want in law. All I want to say is that we do have a very good law. It protects, exploitation of people who are, underprivileged. And, you must remember that we have 12 forms for living donation to protect those people, and only 2 forms for disease donation. So you must remember that what we need to do is we need to identify where are the problems. And I would tell you the problems are in the hospital domain, not so much in public domain. And I'll tell you this why. Because you must remember that every day we have about 35 people donating eyes, spontaneously from home. We also have 11 million blood donors in this country. So our people are very giving. So our problems are mostly in the hospital domain, and we need to put good processes in place if we want to put disease donation in the front of, in the country to take care of, organ shortage. And other points like brain death and everything needs to be resolved. I mean, these are simple things. They don't cost any money. Just putting, the word brain death in the Death and Birth Act is not going to cost any money. It will make the whole thing uniform. So simple steps, simple measures, doesn't require any resources. So if we do that, if we relook at this, I think we'll fly. Thank you.
Thank you, Dr. Shah. Thank you. Dr. Bharat Shah, sir.
So Parag, I'll make 3 main points. This meeting is for organ transplant. And we talked about uniform date definition, but that will not increase organ donation. So I don't think at this point in time, this is an issue for organ transplant. I brought out the point of needing to identify more non-transplant organ retrieval centers. We should not be waiting for application to come from the centers because they don't benefit. I think the government should work hard and have a drive to identify more and more non-transplant organ retrieval centers by simplifying the process. And third, since we have an opt-in system, we should have a system like when they go for renewal of license, they should be able to pledge organs, or when they apply for an Aadhaar card, there should be a system whereby they can apply or pledge for organs. So these 3 things will really help improve our program.
Dr. Swarnalata, you're working with the masses. So, ma'am, please.
Yeah. So I have 4 points to make here. One is easing the process of brain death. And particularly, like, the government hospitals, like all the hospitals which have a facility for ICU, they should be encouraged to be a part of this program, have a counselor, and they should actually, like we have Arogyashri. So they should have some audit system that all these patients who are coming in coma, they should be audited, and then they should, tap those patients because these are the potential area where we can have a maximum number of donations.
Right.
We should basically tap those areas. And the third thing is, like, there's, as has been discussed, there's a fear psychosis among the doctors. So you should be able to remove that fear psychosis and make doctors comfortable in coming forward and doing declaration or whatever maintenance is there. So this, and the fourth would be the public awareness. Even that fear psychosis should go out from the public, that, organ donation, something like exploitation or something like that.
Thank you. Thank you, Dr. Swarnalata. Dr. Dhruva Chaudhary. Sir, over to you, Dr. Dhruva.
Thank you, Parag. I think it has been an interesting discussion. I will put up 2 or 3 things. I'd like to see it start at home. So I would like to go for the training of the doctors and changing their attitude. That is the single important block there. Even in the ICU also. I think if we start from there, they are the game changer. Whatever rules you make. So the first thing is the people in the medical profession need to change their attitudes and practices. That is number 1. Second is, we are to involve more public sector, as has been said too. 3, training of the people from general surgery, from internal medicine, and other places in your organ transplantation, because large number of places you don't have it. So the third is increasing the organ retrieval center as the first step, and then do it. So these are the things which you have to a retrograde chain from where you retrograde extension, which will be there, or back to the only way then we can move up. Rest we can keep on discussing everything.
Right. Dr. Lalit Shah, 15 seconds, sir. Okay, I think sir is not hearing us. We'll move over to Dr. Vasanthi Ramesh to give us the last word on the doctor side. Ma'am. Ma'am, we can't hear you.
Am I audible?
Yes, ma'am.
Okay. The most important thing that I would like to say is we have to have transparency, and that has to be reflected by the data that is submitted by each and every hospital, which is a transplant center or an NTORC, to the national registry. Because without that, we cannot make our intentions clear, and therefore it is of utmost importance. And this has to be online and real time, so that our ultimate aim is to have a digitized allocation based on this. Are the slides visible?
Ma'am, it's a rapid fire round. We won't be able to take slides now. So you can just wind up.
So
Yeah.
the most important thing is that Noto, Roto and Soto, which are all connected by the same website, should have real-time data so that the transparency is established and digitized allocation can be there. Then the other thing is quality and safety. For that, we need to have post-op follow-up details and also adverse events recorded on the website.
Right.
And then the empowering of Noto, because without that, with this health being a state subject, people refusing to comply with the laws. So when there are multiple authorities, ultimately nothing happens. So we have to devise a law whereby there will be a single authority, because this is a national activity. It is not restricted to a state or a center. So there has to be a single authority to which all will report and abide by. This has to be by consensus. Only then it will succeed. And of course, as Dr. Dhruva Chaudhary said, training of ICU doctors and more transplants in public hospitals, that is of essence to increase the organ donation.
Thank you, ma'am. I'm going to ask a quick question to our delegates from Spain. I don't see Dr. Ajit if he's still there. Dr. Maria, Dr. Joseph Palmero, and if I can see Dr. Ajit, please. And Dr. Ratna Devi as a patient advocate, if the four of you can quickly in 2 words tell me and help me out. Should India go in for an opt-out kind of a structure for organ donation? Dr. Maria Gomez.
Yeah, I think that I mentioned briefly during my slide. I think that there is not a matter to go to opt-out legislation. Recently, there are some countries that they changed their legislation. We have Holland here in Europe, and first was Wales, and now all UK is moving to opt-out legislation with no increase in the donation rate. So opt-out is not the solution for increased disease organ donation rate. There are countries with opt-in legislation and a good donation rate. One of them is United States, no? That is right now like 3rd or 4th in the world with good disease donation rate. So it creates a lot of controversy in the population. India is not ready for those controversies. This is not the way to go right now in India.
Thank you. Dr. Joseph, Dr. Palmero, please, your views.
Yes, for me, there are two things. One is increased information drive in TV, radio, and social media for organ donation. And number two is for the hospital. There should be more transplant coordinators in every hospital so that there will be an increase in organ donation. Thank you.
Thank you. Dr. Ratna Devi, your views. Should India go in for opt-out legislation?
I do not think we are ready for that yet, considering that there is so much of mistrust and misconceptions amongst the general population as well as the patients. So my suggestion would be that you have a stronger communication strategy that's multifaceted and towards all stakeholders, not just doctors and patients, but media and everybody else, like we mentioned, and an official recognition of a patient body or civil society that is also helping Noto and Soto and other government bodies to talk to the donors and the recipients.
Okay, thank you very much. I hand over the microphone to Dr. Ravi Shankar. Sir, I'm going to sign off here, and I'd like to place on record my gratitude. I have to join the thing on Telehealth. Dr. Ravi Shankar, over to you, sir.
Thank you very much. Thank you for having moderated beautifully the whole session today morning, on a Sunday morning. Just to summarize what things have happened right from 9:30 in the morning. Thanks for the opportunity given to me. I think I will have to go by individuals, what they have insisted upon to make a better law in this country for the organ transplant to be taken forward. I think Dr. Lalita said that, as our MP has already given a statistics of so many people waiting in the country for the kidney and the liver. The big gap is there between the demand and supply. And the demand and supply has to be met with, I think, that second tier and 3-tier cities also should be able to provide the transplant facilities in this country. And the cadaver transplant has to be encouraged, and the families will have to be encouraged to take forward or to accept the reality of giving a transplant donor from within their family. Dr. Sunishala from my own city of Chennai, a much experienced person on it, has given a lot of input mainly on the medico-legal cases which are getting delayed. And everybody who has spoken have already told about a uniform death declaration and the importance of the next of kin to be given the option to do or not to do a donor. And the clarity on the death certification has to be there, and that is Sunil Charof's important point. That he has stressed that finally that Indian population have been very good in donations. The way how the cornea and the large volume of blood donors are there in this country. And if the law is being more favorable or fine, I think we will get more organs in this country. You have Dr. Rahul Pandit. Again, the brain death definition need to be clarified, and you need a uniform definition for the brain death. And more, he stressed upon the ventilator switch off. The doctor or the medical community should be given the right to switch off the ventilator. Today, do not resuscitation is not valid in the court of law. If that is there, it is not possible for the medical community to go forward and take the risk and trying to remove the ventilator, even if the patient's relatives give a concern. Most of the time, what is practically happening in this country, I'm also part of an intensive unit, a small unit in spite of it. It is not possible to remove a ventilator, even if the attenders accept it. You know, the large volume of medical colleges, even if when they want to discharge a patient before death or for anything, they always send the patient in the ambulance, and the ambulance comes to one of the hospitals which is known to the patient, and from that point of time, they try to remove the ventilator. This is the practicality that is happening in the country. I think our MP will be able to realize the difficulties of a hospital to do this. Dr. Bharat Shah has given one major point that organ retrieval can be happen in many other places. Don't need to be given a permission or just to be monitored by a major transplant centers. Everybody was stressing upon that the law should be a little more easier. More importantly here, the fear psychosis cast upon the doctor that they are not willing to do certain things, taking a risk on the profession because the law is there. And I have to pass a comment on this. When a law is enacted in this country, it doesn't get implemented in the right way in what it has been implemented. It has been brought forward. Most of the time, people who implement the law take the law into their own hands for their own ends. That is the one thing that has made the medical community in fear of the doing certain things which will be better for the community. Dr. Duro, who been part of a public sector, I think stressed upon the point of private-public partnership, the difficulty in the public sector on the infrastructure, and again the organ retrieval and brain death. And he stressed a point that the leadership should be there to take it forward. He stressed upon on my own state, which I will tell a little later at the end of the session what my state has really done it. And the leadership needs to be there to take forward everything in a better way. The Kerala government, though has enacted an act, as Dr. Mohammed has said, unless a central act is there, I don't think the medical community will abide by it. It's a classical example what has happened in Kerala. Though they have a good law that has been enacted locally to retrieve the organs in the ICU or whatever it is, it has not been effective. So unless a central law is there, it will never happen in this country because the fear psychosis among the doctors that they want to play safe. Dr. Mathur had given an example of what is happening in Maharashtra. Probably me from Tamil Nadu and he from Maharashtra will be competing with each other who has the maximum donation in the state. And everywhere, here again, he stressed upon that blind death legislation and certification and the process of certifying the cardiopulmonary death everybody is talking about simplifying the process of death certification. And more importantly, he stressed on ICU Death Audit Committee. Here again, I would like to stress upon the point that somebody has told that in the ICU staff should be able to motivate the attenders for a brain or an organ donation. I think it is unfair, or it is not possible, for the reason when a treating team cannot go and try to motivate the patient's attender, because the suspicion will cast upon the patient's attender side that these people may not proceed properly on trying to recover the patient. They might be going towards a process of end stage motivating only for the organ donation. I think the ICU team should not be there. There has to be a separate counselor, that which the public people have already told about it. I think Dr. Sarmalaka was talking a lot about that, that you need to have a good team of counselors who should be there to come and motivate the attenders for the organ donation. He was talking a lot about the present COVID crisis that is happening around. And I think Dr. Vasanthi, the voice of the people, has really given us a lot of things to be taken about the resolution that has to prevent the commercialization. I think because of the issue of commercialization, which the WHO and the has given a guidelines that we have an act in this country. This act is, as Dr. Sunil Sharaf said, it is really good enough, but then how to be implemented in the right way, that is what it is to be there. And everybody has been talking about this MCI curriculum on the medical education, that we'll have to talk about all these things. Even a soft skill, organ donation, how you take care of the patients. It's not been taught in our curriculum, but then the last 1 year, I think the MCA has changed the curriculum, and it is now taking forward in a better way, I think. And there's a lot told by Dr. Vasanthi about the media. I think in the Indian context, it's the media that takes a major role to make it good or bad. And I think the media also should be educated on the organ donation and how to motivate it. And I have to quote from my own case of Tamil Nadu. We have got several movies that has encouraged organ donation, and has also given the bad side of the organ donation also. My state is known for a green corridor that has been created for the movement of the organ that has been derived in one part of the state to the other part of the state. Dr. Harish Pathak has said about the clarity on the documentation for the death recipients in corporate hospitals and permission and intimation. Great talk about what is the definition for permission and intimation. That is what I said. When the law is enacted in the country, it is most often misused by the people, by the end implementer. And that is where it's the permission is different, intimation is different. When I intimate, I can just go and proceed and do what is needed for the patient. But when it's a permission, I need to get back a letter from them that they have been permitted to do the such and such job. And I think that is where the law is being misused by the end implementer. Dr. Ratna Devi, a lot about the counseling, the positive donor side, the legal challenges about brain death being accepted from the other side. That is on the patient side. That is where we need that counselors who should be able to make things forward for us. And I think we heard from other people from the other part of the world how it is happening in Sri Lanka. In fact, I would like to add a point about it. The religion that is majorly being followed in that country should have encouraged organ donation, which has really not taken up. Probably the country has not given a lot of importance for it, or the medical community has not taken it in a big stride. I think that religion also has a major role in most of the countries. I think that is where Dr. Sunil Sharaf showed that the Indian context, the Indian population is very much willing to donate, make for the cornea as well as the blood donation, what he has also said. And what has happened in Spain, the growth has happened because it is much earlier in 1989 onwards that has been there from Spain. That's why it has gone to a greater way in that country. And the most important issues that has been going on, summarizing everybody, was the legal hire who has to take the decision, how we motivate them, how we counsel them, how we make them convinced that organ donation is a very important aspect that is needed for the country, as well as sometime later, somebody in their own family might need it little later. A lot to be simplified on the road traffic accidents and the medico-legal issues where autopsy should be done or performed to the minimum extent in the place where the organ is being retrieved, which will make things easy for them. This is one point that most of the patients attender will ask us, when will the body be handed over? If it takes 24 hours, if it takes 36 hours, I don't think it will encourage the family to take forward the organ donation. Uniform death certificate is an important issue, and today everybody has said opt in and opt out. I think it is still not in this country possible. Non-organ transplant retrieval center should be there. Private public partnership, a good leadership also should be there, and preventing commercialization should be there in this country as usual. Just a few words about what happened in my state of Tamil Nadu. Stands number 1 in the country for cadaver transplant for the last 5 years in succession. I think everybody will be aware of it. One major important that has changed in Tamil Nadu was the government insurance was provided for transplant economy. When we say that all the transplants are happening only in the private sector, I don't think what I'm going to talk now is relevant for lawmaking or anything, whatever it is. But as a social responsibility from the medical community, from people like us, I think economy is one issue which has prevented organ transplant to be taken in a big level, and why public sector hospitals and why government hospitals should not take it in a big way. Tamil Nadu is an example where the Chief Minister's insurance scheme is providing a good chunk of money for both renal, liver, as well as heart transplant. That's the reason why we have a higher index of people coming in for transplant in our state. And the fear psychosis, which has to be dispelled off in the society, is a very, very important factor that which have to take it forward. And all those, it's a fear psychosis of the doctor, and the fear psychosis of the public, and the organs will all be retried, and they will not give a proper body. They can't see their face, and that is what the public is always feeling. The right of the public should also be encouraged and done it. I will just quote one simple thing. When you can get such a large volume of cornea transplant and large volume of blood donors in this country, making a law simple for a corneal retrieval, why should not the organ retrieval can also be made so simple? Why should not the cadaver retrieval cannot be made so simple? I think it is left to the justice people and legal people, and it's left to the administrators like our MP to take it forward and see it much simpler. And since I have to start the opening note, I was not able because of the connectivity problem. I think this is the one organization, Institute of Medicine and Law, that has really taken forward most of the legal issues, no, not most of all the legal issues pertaining to the practice of medicine in this country. And I have to compliment Mr. Ravindra Mangal and Mr. Mahendra Kumar Bajpai. Look, they always say National Convention on Medicine and Law. Man was born. First, he needed a care for himself, for his health, and then only the law came into existence. So I think law and medicine was being blended so beautifully by Mahendra Kumar Bajpai and Ravindra Mangal. I think every one of us has got a responsibility when the need for organs is so high in this country. Our MP knows the demand for the organs, and I think the Spain model could also be taken forward. And I think media should be used. I think administrators can bring in a simpler law. When the law is only 13 pages for the Transplant of Human Organ Act, we need hours and hours of working together to make it much better for us. I think with a proper leadership right now and in our country, I think our people will be able to provide us a better, easy law and encourage the organ transplant in this country. Thank you for the opportunity given. Thank you very much.
In this first session. Now we are going to start with second session. The viewers are requested to stay on. The second session would be starting in a few minutes from now. Thank you.
Sure. Okay. Good morning, dear panelists. I welcome you all on behalf of Institute of Medicine and Law to this interesting session on telehealth. We have had a great discussion in the first session on organ transplant, and I hope we will have an equally or more exciting session now onwards. We have Justice Sunil Ambani ji, who is the chairperson for this event, and Dr. Dilip Walke, who is the convener. We also have Dr. Parag Rendani, who is going to moderate this session. Before we move on and I ask Dr. Walke to take over, I would request our CEO, Mr. Sundarajan, to speak a few words. Over to you, Mr. Sundarajan.
Thank you very much, Raviji, respected Chairperson Ambani ji, esteemed panelists, and dear friends. Welcome to the 5th National Convention on Medicine and Law 2020. Before we start the proceedings, I just want to clarify as to why we are here and the purpose of why we are here on this Sunday morning. India is a functioning democracy and undisputedly the world's largest, but it has its own set of problems. Some problems have solutions, some don't, but to solve the problems which have solutions, change is required. One of the ways in which change can be brought about in this constant, dynamic, ever-changing world is through law. Law perhaps is the most effective tool to bring about changes, big changes, and changes very quickly. But how does that change in law happen in a functional democracy? Well, the theoretical answer is just change the law, or go to policy makers and legislatures and get the law changed. But bringing change in that law is not very simple, not very easy. Problems have to be identified, solutions have to be identified, and sometimes there are people who will disagree with the solutions, and the solutions are diametrically, completely opposite. So at least a broad consensus has to be arrived at before changes in law are to be made. And these have to be put before opinion formers, the media, the press, and voices have to be raised at different intervals, at regular intervals. We at the Institute of Medicine and Law are in the domain of laws applicable to medicine. We come across different stakeholders in healthcare, and the problem that plagues healthcare in India are very large. Some are humongous. Some need solutions, perhaps immediate change in laws. This convention is a very small step to identify, raise, discuss, deliberate problems faced by healthcare in India, to find out what is the legally correct, legally acceptable solution that is also democratic in nature. So 2 questions that I must answer to this panel and to the viewers is what will be done with the recommendations of this convention, and most importantly, will it bring change? So I have a firm answer on the first one. The roadmap is ready. We will prepare a white paper of both the sessions, and we had a wonderful first session. Of both the sessions, we will make a white paper and share it with media, policymakers. Historically, this white paper has always been revered, very importantly, has been taken very seriously, and we will be holding up follow-up meetings and events to ensure that this white paper reaches its logical conclusion. So this white paper, which is the output of this convention, is the beginning and not the end. As far as the second question is concerned, whether change will come, my answer is it may not. We raised a lot of issues previously. This is the 5th convention that we are holding. So we've raised issues in the past 4 conventions. Uniform determination of death were raised in the 2nd NCML in the year 2016. And this year in January, Kerala has made requisite changes in law. We raised the issue of virtual autopsy in the 3rd NCML in 2018. And last year, the Honorable Union Minister stated in the Parliament that the government was moving in that direction and that virtual autopsy is now being adopted. We certainly don't claim credit for these changes, but we are amongst the first to raise voices in the direction on the right issues. There's one assurance that I can give all of you, is that these recommendations of these convention will be taken to the relevant authorities, to the policymakers, to the opinion formers with the same enthusiasm and determination that we have been doing so far. Once again, on the behalf of Institute of Medicine and Law, I welcome all of you. Thank you very much for joining here today. And Mr. Ravindra Mangal, kindly take over from here.
Thank you so very much, Sundar, for your kind words. May I now request Dr. Dilip Walke to open this session and we start the proceedings. Dr. Walke, you'll have to unmute yourself. Every panelist is on mute. Before speaking, you all have to unmute yourselves.
Right. So thank you, Ravindra, and good morning, ladies and gentlemen. At the outset, let me thank the Institute of Medicine and Law, especially because this topic is very close to my heart. Being an end user as a doctor and also as an entrepreneur, for having started an app as much as 2 years back before the 25th of March. We are meeting today. The agenda is a holistic view on telehealth and a little microscopic view on the telemedicine practice guidelines, so that ultimately we will discuss about the challenges that we are facing in our day-to-day practice as an end user, and to suggest solutions both for the end users and the policy makers, as Sundarajan told us. So to set the ball rolling, what we have done is initially there are going to be 2 presentations, which will be followed up by a panel discussion. So these 2 presentations are by one Dr. Reena Gupta and Dr. Sanjay Shud. May I invite Dr. Reena Gupta to start off her presentation.
Thank you, Dr. Walke. Are you all able to see my presentation at this time?
Not
Okay.
yet, Dr. Gupta.
Okay. 1 second.
Yes, Dr. Gupta.
Okay. Thank you so much, Dr. Walke and Mr. Mangal. It's a pleasure to join the 5th National Convention on Medicine and Law to speak today about our experience with telemedicine as a case study for telemedicine with hypertension and chronic disease care during the COVID pandemic and beyond. Resolve to Save Lives is an initiative of Vital Strategies that works in partnership with the WHO, CDC Foundation, World Bank, and the Global Health Advocacy Incubator globally with governments to scale up effective treatment of hypertension and promote cardiovascular health, along with preventing epidemics. In India, Resolve is a technical partner with ICMR and WHO India to implement cardiovascular health programs to the community level with the states and ministry. Telemedicine is truly having its renaissance moment during the current pandemic now. As we all know, though telemedicine has been discussed widely for many years, till now the structural, regulatory, and financial barriers have really limited the widespread adoption. But in response, early on in the pandemic in March, many countries rapidly released modified regulations and reimbursement policies, such as the guidelines in India, along with regulation changes in China, the US, and elsewhere, that have resulted in the unprecedented rapid expansion globally over the past 3 months of telemedicine services to maintain continuity of care during the COVID pandemic, to minimize exposure to patients. But beyond playing a key role in maintaining essential health services during the COVID response, telemedicine is moreover a long-term strategy, especially in geographically remote regions, for providing patient-centered chronic disease care at the community level. And clearly, further evolution of the telemedicine regulatory framework as is being discussed in the session today is vital to harnessing the potentials for telemedicine and telehealth more broadly, while ensuring careful consideration of the data security and privacy issues, and addressing the limitations of telehealth and integration in the broader health ecosystem. At Resolve, we developed a guidance for implementing telemedicine programs for chronic diseases in low and middle income countries with 7 key components. First and foremost is addressing the legal and regulatory considerations, followed by identifying the telemedicine users, choosing the appropriate technology platform, aligning financial incentives, defining workflows, reviewing the importance of appropriate use of telemedicine in training health workers and engaging patients. And I now want to share briefly on the model for simple telemedicine that's being deployed to empower community health workers at health and wellness centers in states in India to manage and treat hypertension and diabetes patients in the community through consultation with medical officers. Simple is a radically simple application designed to support large-scale hypertension and chronic disease management programs that is free, open source, and interoperable. It was developed through user-centered design to ensure that it is fast and easy for health workers to use it. In fact, a follow-up patient can be recorded in less than 20 seconds, and it can be used offline on a personal device for busy OPD medical officers or health workers when they may not have a laptop or working internet. And as of May 2020, it's being used in over 1,500 public health facilities with 3 lakh patients registered in Punjab and Maharashtra states. In response to the pandemic, telemedicine features were deployed via Simple in these 2 states in partnership with ICMR and WHO India. The model features telemedicine between community health officers at the health and wellness centers and medical officers at the PHC level. And when a patient visits the health and wellness center, the community health officer can open the patient's record in Simple and request a teleconsult with an MO in one click. The medical officer then receives the teleconsult request with a link to the patient's record and can initiate consultation via audio or video as appropriate. So overall, the feature is simple and fast service to use. Therefore, uptake is efficient by healthcare workers. It makes their job easier, which is often the barrier with more cumbersome telemedicine or health record platforms. It does not require any new hardware. They can use their personal devices, and it functions offline without internet, so can be used in most rural regions and follows industry standards for security and privacy. COVID-19 has catalyzed the rapid expansion of telemedicine that we have all seen, but its longevity will hinge not only on the technology, but more so on the regulatory framework and financing structures to harness the potential of telemedicine to extend the reach of primary care in low and middle income countries, while also addressing the limitations of telehealth and monitoring quality and patient safety. With that, I will turn it back over to the moderator. Thank you.
Thank you, Reena, for the presentation. And to set the ball rolling, may I request Dr. Sanjay Sood now to make his presentation.
Thank you very much, sir. At the outset, I'm delighted to be a part of NCML, and I thank IML for the same. Well, I'll talk about the National Telemedicine Service that has been recently launched by the Ministry of Health and Family Welfare, Government of India. The National Telemedicine Service is available in 2 variants, and eSanjeevani is the telemedicine flagship telemedicine platform that has been deployed in both these variants. The first variant is supporting or is facilitating the implementation of Ayushman Bharat scheme, which is the world's largest health insurance scheme, wherein eSanjeevani at health and wellness centers is being implemented. Around 1,55,000 health and wellness centers will be enabled with telemedicine through eSanjeevani HWC, and we've done so in 8 states, and 2,000 health and wellness centers have already been enabled. We've trained around 7,000 users, which mostly are the doctors in the hubs and the health workers or community health officers in the health and wellness centers in those 2,000 HWCs. And we started this way back in December 2019, and close to around 60,000 consultations have already been completed in this network. On the other side, as soon as the telemedicine practice guidelines were released by the Government of India, and in the period when all the OPDs across the country were shut down because of the pandemic, the Ministry of Health and Family Welfare wanted to roll out a patient-to-doctor model wherein the eSanjeevani technology was then customized or modified to be used in this format, and we launched eSanjeevani OPD in a very rapidly developed format. The guiding philosophy was that perfection is the enemy of good. So we had that in mind. The directions from the Ministry of Health and Family Welfare, that they thought big, and they started small, and then the scaling has been certainly faster. So we've launched eSanjeevani OPD on 30th of April, and it's reached out to 18 states. We've covered 75% of the populace can make use of these telemedicine services available through eSanjeevani OPD. 1,770 doctors have been onboarded, and we've already done 19,000 consultations. As of now, we're doing around 700 consultations a day in the entire network. And I'll be taking you through the processes those are involved in eSanjeevani OPD as of now, because this is the newer model which has been launched by the government. The patient is required to log on to the website esanjeevaniopd.in, or we have an Android application which has been launched very recently, around 10 days earlier. The patient verifies the mobile number, registers there. The entire registration is based on the electronic health record guidelines of the Ministry of Health and Family Welfare. The system generates a token, and upon getting the notification from eSanjeevani, the patient logs in, and that notification could come in 10 minutes after getting the token, or maybe 2 hours or 3 hours after the token is generated. Depends on the people in the queue, so that the patient doesn't have to wait after logging in. So once the patient logs in, waits for the turn, there's a specified queue there in the waiting room, and gets into the consultation room and speaks with the doctor. The doctor writes down the prescription, e-prescription, which is again centered around a nomenclature, and then the doctor shares the e-prescription with the patient, discusses that, explains it to him, and then once the patient is okay with it, the e-prescription is the consultation closes, and the e-prescription shows up on the screen and is also sent as a link in the SMS to the patient. So this is the format of the e-prescription which gets generated in eSanjeevani OPD. And we also have a mobile app, as I mentioned, the Android app. We launched it last week, and around 10,000 downloads have already happened. And around 17% of the consultations have started, patients have started using eSanjeevani's Android application. And these are the states where we've already rolled it out, and around 6 states are in the process, in the various processes of rolling it out. And that is the homepage as it shows up on esanjeevaniopd.in. We've done around 2,200 plus hours of consultation using eSanjeevani OPD, and we have up to around 200 doctors practicing telemedicine using eSanjeevani OPD at any time in those 18 states. And states like Kerala and Tamil Nadu, they're really using it aggressively. Kerala uses it 12 hours a day, 7 days a week, and it becomes really a challenge for us to update and maintain eSanjeevani. So that is the national dashboard that we have. Various states, something like 18,000 plus consultations done. This was yesterday's scene. 703 consultations we clocked, 94 hours the doctors had put in, and an average consultation duration there is 7 minutes and 16 seconds. And that is the view of the state dashboard. Rajasthan, that they've done, this is a bit older, 1,600 consultations, put in around 200 hours. And then various other features have also been given to the administrators at the national level as well as the state level. They get to see which doctor is online, which doctor is offline, which doctor is in the consultation, how many minutes and how many consultations has the doctor put in, and it also enables an individual to use eSanjeevani for his or her dependents. We have a number of specialties also rolled out. Initially, it showed up as one OPD per state, but now today we have a provision of opening n number of OPDs parallelly, concurrently they're operating. For example, in PGI Chandigarh, they're coming up, just the eye department is coming up with 6 OPDs which will be running parallel on eSanjeevani OPD. Kerala has, that is the inside view on the patient end. The patient gets the call, has the privilege, has the option to receive the call for 2 minutes. In case he doesn't receive, he goes back to the queue. And once on the doctor's end, as soon as the patient clicks, he gets a call, and the doctor accepts it, and that is how they get connected with each other. And that is the SMS daily reporting that we provide to the state as well as national administrators, that these many hours of consultation have taken place. That is the average patient wait time, and those are the number of consultations that have happened on that day until the beginning. And we've also localized e-Sanjeevani OPD for various states like Kerala. We've done it for Kerala, we've done it for Tamil Nadu as well. Kerala is, as I said, using it for 12 hours all the 7 days. They've also started using it as in the correctional facilities in Palakkad district jail. They're using e-Sanjeevani to get consultations for the inmates with the specialists. They've also onboarded Indian Institute of Diabetes, Thiruvananthapuram on e-Sanjeevani OPD, and they are enabling NCD, hypertension and diabetes consultations over e-Sanjeevani OPD, and that is how we've scaled it up to the next level, wherein that is the page for Tamil Nadu, and that is how we've scaled it up, even included specialized consultations on board, and accordingly we have a fair percentage of specialized consultations also. Punjab has opened out specialized OPD Gyne, online OPD for Gyne, daily 8 a.m. to 2 p.m. And that is how we are working towards it. We've deployed it on cloud. It is very secure and flexible, and we can in a matter of minutes scale it up to 10 times of its capacity. And considering the experiences of the Ministry of Health and Family Welfare, the defense services have also rolled out services e-health assistant consultation, that is Sehat OPD, again using e-Sanjeevani technology. And we've done it for them. A pilot rollout is already on. We are customizing it to give it a better shape and get the features that they want. So the defense personnel also have e-Sanjeevani technology being available to them in the format of services e-health assistance teleconsultation module. So that is how the doctors are practicing telemedicine. That is in Rajasthan, and even while waiting for, or while doing, that is the kind of OPD, online OPD that shows up in Maharashtra and then also in Rajasthan. And that is how the doctors are adopting this newer model of e-health services or health services delivery. There are certainly numerous challenges and requirements which can be met from the legal and the regulatory aspects. We'll get to talk about them as we discuss this further. Thank you very much, sir.
Thank you, Dr. Sood. I believe there is some problem with Dr. Walke's internet connection. So I will now request our moderator for the day, for the session, Dr. Parag Rendani, to take over.
Yeah. So very good afternoon, all of you, ladies and gentlemen. At the very outset, let me introduce the two speakers who spoke. We didn't get an opportunity to hear about their credentials, and I'm sure our viewers on the IML YouTube would be very excited to know that who we have with us today. Dr. Reena Gupta is an Associate Professor of Medicine, Division of General Internal Medicine at the University of California, San Francisco. She's also the Chief Medical Officer for Performance Improvement, Cardiovascular Health, works with Resolve to Save Lives, which is an initiative of Vital Strategies. Dr. Reena Gupta, thank you for a very lucid presentation. We welcome you today to this session. We've already gone through your presentation. Thank you, Dr. Gupta. And we also heard Dr. Sanjay Sood, who's an Associate Director and Project Director for e-Sanjeevani OPD with the CDAC Mohali, which is our very own ingrown Center for Development of Advanced Computing. Dr. Sood, thank you very much for a very crystal clear presentation. And I think the private sector has a lot to learn from e-Sanjeevani. Thank you very much for that. I will now invite, in the interest of time, we have certain speakers who have certain conflicting sort of commitments. I'll invite Mr. Subal Dikshit, who's the Director ICU, and Dr. Subal Dikshit, Director ICU at Sanjeevan Hospital, immediate past President of Indian Society for Critical Care Medicine, and immediate past Chancellor of the ICCCM. Over to you, Dr. Dikshit.
Yeah. Thank you, Indian Institute of Law, for inviting me. It was a brilliant talk by Dr. Reena and by Dr. Sanjay Sood. It was really heartening, and I would first of all like to congratulate the government for officially legalizing the telemedicine concept in India. But I'm into intensive care practices. I'll have definitely certain things which should be taken into consideration. Yes, it is an excellent tool for OPD for cold patients, especially for diabetes, blood pressure, and what is going on. For especially now, for thing is, the Indian Institute and the government should also take into consideration if any patients who are on the borderline, like a pneumonia patient is now scared to come to the OPD and he wants to consult and do a telemedicine. How is it legally safe to advise, give a legal advice on such kind of patients who are on the brink of an hospital admission, especially into these subset of patients? So that is one thing which really concerns me, and it also bothers me also. Okay, I've had two, three patients who have contacted me on telemedicines. When they showed me the X-ray, they did have a fluoride patch onto that, and he just scared that he doesn't want to get admitted to the hospital just because that he will contract COVID. What are the legal implications? Are we legally safe into such kind of opinions? And how, like in the OPD practice, normally we say we have advised an admission, and he is deferred it. So what is the concept and what is the thought, especially for dealing with these borderline critically ill patients? So that was one thing which was hindering my mind.
Thank you, Dr. Dixit. We'll come back to these queries, and I think the whole purpose of today's discussion is to put down these queries, and we'll just take it forward. I'd like to now invite Dr. Colonel Ashwini Goyal. Dr. Goyal is the President-elect of Telemedicine Society of India. He is a member of the International Society for Telemedicine and E-Health. Dr. Goyal, over to you for your discussion points, please. So you'll have to unmute yourself, please.
Yeah, thanks. Thank you, Dr. Randani. It is heartening indeed to be a part of this highly enlightened panel. As Dr. Parag has already mentioned, I am currently the President-elect of the Telemedicine Society of India. And this is the society that is recognized by the Government of India as the lead agency that is promoting telehealth in India. So a few thoughts on today's issue at stake. Firstly, let me just reiterate that the telemedicine practice guidelines are not a substitute for actual physical encounter between the RMP and the patient. It in no way substitutes a clinical protocol. The clinical protocol is applicable. And what we have to keep in mind is that telemedicine at best is an enabler for good clinical practice. It is not a total substitute. Now, having said that, see, it is a no-brainer that the telemedicine impacts positively the entire paradigm, or what we would prefer to call it, not really telemedicine, because which is a very niche area. It is more correct to call it telehealth, because it impacts the entire paradigm of healthcare delivery in India. So what I perceive is that there are three issues at stake as far as the today's discussion is concerned. I would categorize them as the legal and regulatory issues, which is, of course, a major bugbear. It has been for the past 20 years, which has given rise to a lot of apprehensions in the minds of people who are practicing clinical medicine in India. Second is under the present telemedicine practice guidelines, it is the constricting nature of the medicines which have been made permissible for use that again is causing a lot of queries in the minds of the clinical practitioners. And third, I would say, is what has been pointed out earlier also, the indemnification process and the insurance and regulatory mechanism. So, what is the role of the IRDA as far as the telehealth practice in India is concerned? Now, as far as this particular discussion is concerned, there is the issue of how is the legal process going to impact or can impact the practice of telehealth in India. So, we all know that it is for a long time now that after the Justice B.N. Sri Krishna Commission, the Privacy and Data Protection Bill was passed, and it is yet to be made into law, because the security of data and its privacy of patient data is a major issue globally. It is the world over, and there are a lot of inimical elements who have made it a business to deal with to hack data and to deal with data in a commercialized manner. So that is what we need to really be guarded against. A second issue that is very pertinent to the telehealth practice is that since it is a nascent area in India now, we need to, though we have been at the government level, these efforts have been going on for standardizing the practice of telehealth in India. Because to ensure quality, you need to have certain standards. I'm very happy to note that recently there have been fresh attempts at defining standards. A number of agencies are working towards it. NEBH is one of them. The Quality Assurance Institute is one of them. The efforts are going on, and to bring in quality and to deliver quality healthcare, standards are to be defined. That is another issue. Third would be the licensure laws as are applicable in various other countries. At the moment, the telemedicine practice guidelines do not speak of state-specific licensure laws as far as telehealth is concerned. At the moment, the practitioners are permitted to work across state boundaries. What the future foretells, it is yet to be seen. And of course, I've already mentioned the IRDA, because once the entire paradigm of healthcare becomes affordable, more and more people will take on to it, because in the post-COVID area, now telehealth is going to be the new normal. Let us accept this fact, and we have to make this technology, the way of imparting healthcare, more affordable, more accessible, and more accountable. So that is where I feel the IRDA would come in. Thank you. That's all from my side for the timing. Over to you, Dr. Indani.
Thank you so much. I would now request Dr. B.S. Bedi. First of all, I'd like to request all of you to keep your queries and comments crisp so that we're able to get everybody participating. I mean, I really would like to hear from everybody. I'd like to introduce Mr. Bedi. Mr. B.S. Bedi was Senior Director in Ministry of Electronics and IT, and is a member of the National Commission on the EMR, Legal Subcommittee for EHR, past President of Telemedicine Society of India, currently COO of TSI and President TSI NCR chapter. Mr. Bedi, what are the challenges that telehealth is facing today in India? What are the legal challenges, and your views, please?
Yes.
Your mic is,
yeah.
Your mic, please unmute.
Host, admit, please. Yeah.
Yeah. See, thanks for bringing me to this very interesting panel, and of course with the issues which will make practice of telemedicine more acceptable and easy. The first issue, again, we have been struggling all these years to get some kind of regulation, and finally with the great efforts of Telemedicine Society of India, other champions, finally the telemedicine guidelines were approved by MCIs now, Board of Governors, and notified. See, this is the first step. A lot of things were kept in mind to just first to see that the whole field takes off, and there were some cautions so that the doctors should not get discouraged. But ultimately, see, you have seen that the way CDAC Mohali has been given the responsibility to roll it out to 150,000 wellness centers. So the question is, when these kind of things start happening, and also, in passing, he mentioned that they are adhering to some kind of electronic health record. Now, this is a very interesting effort which was made by Ministry of Health. And, you know, in September 2013, the first edition of EHR was notified, which was updated in December 2016. Question is, some of the issues which are being raised for teleconsultation, you know, related to data ownership, privacy, they were also addressed in, you know, EHR. You know, electronic health record has the kind of same importance as, you know, telehealth consult, which also generates a medical record. See, I could understand that, you know, the first guidelines which came, they just to make the whole thing launch, they didn't put the issue of interoperability or use of standards, which in the briefing, I think Dr. Goel also mentioned. This will be very, very important in the long run. Health record of a patient. Any episode which takes place through telemedicine should also form part of that in the long run. See, already National Digital Health Blueprint, that also has, you know, included national EHR standards as a part of the whole, bringing digital health to India. So that blueprint is still in kind of this thing. But this thing is, you know, when we evolve, it will be very good, you know, to first guidelines have come, recognition has come to teleconsultation. So the great step, but slowly future this thing where we do bring that those standards, interoperability issues, which will in the long run keep all these telehealth consultation as part of the patient's health, you know, whole life EHR record, which will be extremely helpful in coming to correct decisions later on about his condition.
Thank you, Mr. Bedi. I'm going to request Dr. G.S. Bhattacharya, who's in charge of Department of Medical Oncology at the Salt Lake City Medical Center, Kolkata, and he's also a Senior Clinical Research Associate at the Newfield Division of Clinical Laboratory Sciences, University of Oxford. Dr. Bhattacharya, over to you, sir.
Good afternoon, and it's a pleasure to be here among illuminaries, and I've been really learning a lot in this session. So let me start off by saying that telemedicine is not a new concept. Its application is starting today. Its application is starting today as we are right now in a situation that we have gone into a necessity. But the process of necessity has must think. So I'm going to try and put it across to you in saying that telemedicine is an extremely narrow area. If we really want to talk about telemedicine, we have to talk about the concept of telehealth, which I think Sazuma appropriate and rightly pointed out. But to encompass everything, and my electronic experts and advisors out here will tell you, this is basically the concept of e-health. E-health, and these are not saints. The first step, in my opinion, is let's get our definitions right and put them right, because otherwise we are going to have major issues coming up as time goes by. That what is telemedicine, what is the components of telehealth, what is telehealth, and how we do it. That's one thing. Second thing is that we have to get into a thing to understand that at the end, telemedicine is supposed to be, or telehealth is supposed to be interaction between a patient and a doctor and a healthcare provider, or between two healthcare providers and two doctors. There is a similar recording which people are talking about. I really want to talk about the patient perspective point of view. In India, health literacy is very poor. I'm not talking of literates. I'm talking of not education in that format. I'm talking of health literacy. It's poor. That's one. Two is that don't forget India has got a rapidly growing geriatric population. So some sort of a mechanism has to be brought into place for people who are not or are technologically challenged, which may be because of visual defects, which may be because of hearing defects. So those have to come in. And we have to remember something is that they must be able to access the telemedia to do whatever they want to. How are we going to do that? That has to be put down into the white paper to tell us what it is. Second most important thing, I think what's very important is the provider, his training, his certification, his credentialization is going to be very important. In my opinion is, this is a process of a lot of learning we did as medical students. And the closer the unlearning processes to the learning process, better will we adapt to the process and then fight it. So I think from undergraduate levels, now the MCI should start getting in a curriculum. And in postgraduate, it should be a mandatory curriculum to see that we can go through it. A variable issue again is supposed to be, as it was rightly pointed out, is how the regulators are going to view this, how practice across various states, how practice against various international borders are going to be looked at. Major issue is going to be insurance. Will insurance pay for these tele-regulations? Will the insurance laws be amended to suit the tele-regulations? And then comes up the question of reimbursements. How will you reimburse the person? How will you keep track of the log times? What will be the cost of the reimbursement in terms of what is being offered? And then is going to be a worry which I always have. Privacy for the patient, the confidentiality, who will keep the transcriptions in what format, how do we consent the patient, or we'll just imply that he's come for a telemedicine, we would take it as an implication. I'm sure this is going to be a major issue because how do we consult it? And last but not the least is, we have to get into a system which is called remote sensing for our patients. The things that we cannot do. I'll just try and put this in one framework and try and put it across to you, that in-home quarantine during COVID has been successful in Israel because they had the remote devices. So another thing to the regulator is remote devising laws will have to come and become much more firm in India. That's my opinion.
Thank you, Dr. Bhattacharya. Thank you, Dr. Bhattacharya. I will now request Dr. B. Shiv Shankar, who is the President-elect of the Indian Orthopedic Association. Interesting to hear an orthopedician's take on telemedicine. How are we going to be able to relate to orthopedics and surgical specialties within this realm, sir? Over to you, Dr. Shiv Shankar, sir.
Thank you, Dr. Parag Randani, for having me here. Thank you, the Institute of Medicine Law. Some of the things as an end user I'll be talking, because I'm not specifically talking as an orthopedic surgeon or as a surgeon. I'm talking as a first time user for telemedicine as a doctor. As we are supposed to maintain the record, if some patient calls at odd hours on a video call, and how to keep the record, because EMR is, I have not opened the EMR, and also can we write down on scribble and keep the paper as data for future use. Then how the EMR works, if the company who provides me the software, if the data is lost by them, whom you are going to blame? Or even if the company shuts down suddenly because of they make loss, and what will happen to the data? And also the security of the data. If I've seen so many patients and my data is all on EMR on a platform, and they're charging at present a lot of money also, and they might blackmail me in future, and they might ask me to give them exorbitant charges in future. That's also my question, because right now some of the EMRs available charges about 5 lakh rupees for 1 to 10 consultants having hospitals. For a single specialty doctor like me in a small hospital, paying 5 lakh rupees is too much for a year annual maintenance charges. And suddenly, even if I have that EMR with me, if they next year ask me 6 lakh, 7 lakh, 8 lakh like that, and they might blackmail me and say that unless I pay that amount, they will not give me that data. That's another thing. And I am not sure whether this company will not sell my data, the patient's data, to somebody which might be of interest. And we have people who can get those data and everything. And if a reaction happens after I prescribe a medicine, and what is the responsibility of a consultant since I have given the medicines over the telephone or telemedicine? Is it telemedicine is improving the applicable only in India, or what is the implications of a outside India patient calls me and my prescription may not be, or my degrees may not be honored in outside India? So what is that implication? Then If a person in India also repeatedly uses my e-prescription and takes on medicine for n number of years, then what is the implication of that? Because if some complication happens because of undue use of this, then who is responsible? Or sometime even a person calls me on a friendly phone call and he might ask me some questions, and I might have given, not as a doctor, some friendly advice that whether if he uses this as in the court of law and sues me, or if, especially if some orthopedic surgeon has done some surgery and if either the fracture is not united or the bone, the implants are broken, as a friend, you can call me and you can ask my opinion. But if you produce the same opinion of me, which is given as a friendly advice in the court of law, what are the implications? These are some of the things which are still in my mind. I want the esteemed panelists to answer these questions. That's all I have got to say, Dr. Parag.
Well, thank you very much. I think you can probably be safely elected as the National President Indian Medical Association, because these are the thoughts that are foremost in the minds of every doctor when he deals with different patients. Thank you very much for penning down those thoughts, Dr. Shiv Shankar. I'm now going to ask Dr. Krishnan Ganpati, who is the past president of Telemedicine Society of India and Neurological Society of India. He is Emeritus Professor, Tamil Nadu, Dr. NGR Medical University, member of the World Health Organization Digital Health Panel of Experts, Director, Apollo Telemedicine Networking Foundation, and Apollo Telehealth Services. Over to you, Dr. Krishnan Ganpati, please.
Thank you very much for giving me this opportunity. As you have already mentioned, I am giving you the perspective of someone who has been in active neurosurgical practice for 45 years and has also spent 20 years in promoting, evangelizing telemedicine. This symposium is entirely on legal aspects of telemedicine. I'm going to confine myself to just two points. I am very concerned, I'm very distressed that most medical doctors in India, I hope there's a large number in this audience listening to this, are
Sir,
issue. Yeah, it's the same issue like last time. Is network is not good.
Okay, we are going to take over from here, and I'm going to invite Dr. Nagendra Swamy, who is founder chairman at Medisync Health Management Services Private Limited. We shall come back to Dr. Ganpati after we hear Dr. Nagendra Swamy, a mentor, a guide for me. Dr. Swamy, over to you, sir. Sir, your mic, please unmute. Yeah.
Thank you, Randani, and also thanks for the Institution of Medicine and Law. It's been really pleasure to meet you all. Fundamentally, we are going through a cusp of change in India with the pandemic adding on to it, and telehealth is becoming a major.
Minutes for yeah. Hello.
Is it?
Dr. Ganpati, we'll just we'll pause you for a minute and we'll hear Dr. Nagendra Swamy, please. Yeah.
Do I continue or wait?
Okay. So now we've handed over to Dr. Swamy. We'll just come back to you in a couple of
minutes. I don't mind. Let him finish.
Okay, Dr. Ganpati, you can continue, sir.
Okay, sorry about this, beyond my control. So I think it's very important that you use your common sense. And I think it's contextual. There cannot be, medicine is not mathematics, it's not precise, it's not black or white, it's various shades of gray. What I tell my more than 500 consultants who have been practicing telemedicine for the last 20 years in the Apollo system, they have actually done 10 million teleconsultations so far, mostly in the public-private sector with several state governments. We have not had a single occasion. The reason is we should be prudent enough. If the audio is not good, if the video is not good, something bothers me, my gut feeling. I'm not happy giving a teleconsultation. I stop there and request the patient to come for a face-to-face teleconsultation. This is the most important thing. Everything is contextual. Ultimately, it depends on good faith. You must have the patient's interest in mind. I don't think any court of law is going to take so cognizant of any action which you do, even if it is an inadvertent lapse. So I think this is a message I would like to pass. Please do not get overwhelmed by the fine print, by all the minor things. Do whatever you think is in the best interest of the patient on that particular day, on that particular time, on that particular occasion. This is the most important. I just have a couple of questions. I won't take more than a minute, which I would like the other panelists and the Institute of Law to answer. Now, my little preliminary research work shows that cases, the United States, for example, is a primarily litigious cases go to court, but I don't think a very small percentage, less than 2% of all cases go to court are concerned with telemedicine or involve telehealth. This is so in most of the other countries. In India, we have been doing teleconsultation for 20 years. We ourselves do about 8,000 consults a day. I really don't think a case would go to court. I would like to have the opinion of the panel whether suo moto, any authority, and if so, which authority can take recognition of an inadvertent error committed during a telemedicine consultation. Number two, where will the case be filed? Where the where the patient is residing, or where the teleconsultant is residing? And for a teleconsultation, you go to the Consumer Protection Forum, you go to a civil court, you go to a, is it just like a face-to-face consultation, or are the rules different? So if there is time, we can have a second round of discussion.
Sure. Thank you. Thank you so much, Doctor. Dr. Nagendra Swami, over to you, sir.
Thank you, Parag. And I would like to thank IML for having given this opportunity. Now, I would like to little shift gears from telemedicine to telehealth, because telemedicine is a subset of the telehealth. Telehealth, on a larger context, we are looking at much more activities that are related to healthcare in addition to the telemedicine, especially being this has now, the present pandemic has given us a big change that has come in the way the medicine is being practiced. Not only by the way of telemedicine, even information transformation, administrative calls, we are taking through the distance. We are also giving a lot of training, especially our CMEs, educational portals, everything is coming through the portals. So when we say telehealth, we include specifically the training and the rest of the issue. The surveillance is also a part of telehealth. I think this pandemic also is giving an opportunity how a public health surveillance can be introduced into telehealth, which can be a major role player. We have ignored public health for quite long in our country, and this can be a game changer using the telehealth applications and try and do the public health little more effectively, which is the need of the hour today. And while we are looking at the law and the things that are necessary, one is the confidentiality of the data, IP rights of the data. How do we have intellectual property rights for the data that comes through the telehealth issues? Suppose we do the research and we write the papers, how do we protect our interest in that? Similarly, legal things. I do agree with Dr. Ganapathy sir, though there is a very small chance of somebody taking us to the court, but still prevention is better than cure. Taking certain minimal precautions like what Dr. Sir's policy over the years in Apollo Group have followed, proper documentation, proper taking care of the patient's notes are vital things. Very, very happy for really decades we were trying to get telemedicine a guideline in this country. Ultimately, a pandemic, I believe there are some silver linings even in this crisis time. This led to us to give us a guideline on the telemedicine very positively from the government. I think it's very necessary. Other than the telemedicine, we need to look how are we going to use this teletech, what I call as using technology to bring various aspects of the healthcare into the dominance area. Especially public health is something I'm very interested, and also to look at how do we have the management, what we call as the parameters which can be exchanged. How do we ensure the data is secure, such things. Thank you. Thank you for the opportunity.
Thank you, Dr. Swami. And I think while I have a few other doctors down the line, I think from the practicing side of the doctors, probably my last representative, of course, I've got Dr. Vikram Dogra a little later as a foreign delegate, and who's going to be speaking about radiology and such other things. Dr. Professor S. Arul Raj, who was the chairman of the Sundaram Arul Raj Hospitals and the national president API 2020. Sir, we're not able to see you, and your mic is also muted. Can you please switch on your video, sir? Dr. Arul Raj? Okay. I think, I don't know whether he's logged on. Okay. In the interest of time, let's move ahead. And before I move on to the advocates, I'd like to move on to technology. Mr. Amit Mohan, who is the business head of LCS Digital and Insight Sales with GE Healthcare, is the India and South Asia region. This particular vertical of business is all about anesthesia workstations, ICU ventilators, and other solutions, including diagnostic cardiology, maternal and infant care. Amit, over to you for your specific issues, challenges with telehealth and the legal challenges thereof.
Thank you, Dr. Randani. Am I audible?
Yes, you are, sir.
Thank you so much. Before I start, I just want to extend my sincere gratitude to the IML to have organized this 5th National Convention on Medicine and Law. And thanks to my esteemed co-panelists for having me with them. Without further ado, and in the interest of time, I'll dive straight into what I have to share with all of you today. And hopefully I should be able to talk about solutions to some of the concerns which has been raised by some of my fellow panelists. The TPG framework as we have it today is praiseworthy in defining telemedicine and telehealth, identifying RMP and the patient, detailing application and the scope of telemedicine, mode of communication, technology used, highlighting key issues in terms of appropriateness of technology, patient consent, patient management, prescription format, fees, drugs used, and most important, ethics, data confidentiality, and privacy. This is our global experience at GE Healthcare for more than 20 years in providing and seeing the continuous advancement of telehealth technology. Briefly, I want to emphasize that the scope of telehealth is much wider than telemedicine. Telemedicine can be a subset of telehealth in terms of providing primary and ambulatory teleconsultation services for basis diagnosis and treatment of common illnesses and medical conditions. Thus, teleconsultation could be between the generalist or a specialist. I will not touch much there. Let me move on to telehealth, wherein telehealth has a much wider canvas. In addition to teleconsultation, some of the aspects of telehealth could be, it can be a boon in managing acute and critical care patients through tele-ICU, tele-operation theaters, and tele-emergency rooms, providing monitoring and surgical and emergency support. Many critical patients can be managed within hospitals or several hospitals through a centralized tele-ICU, what we call as a command center. It may also include remote surgical assistance during or after surgery in OTs or ER settings. Telehealth also includes post-acute care, care during transition or transfer of patients, or even home-based chronic care. For that matter, it can also help significantly in community monitoring of long-term basis. Not to forget that medical education, technical skill building, HIS, EMR attempts in digitizing the medical records, etc., and use of advanced algorithm in diagnosing and managing complex cases are key elements of telehealth. With immense scope, the benefits could also be huge, especially for an emerging economy such as in India, where we are promoting more use of digital technology in every walk of life. Telehealth, if used appropriately, can be a force multiplier in ensuring quality healthcare to the masses through experts at places of their convenience, at the cost they can afford, at the time they need it the most. The data, the decision support tools, the platforms, and the various artificial intelligence models available will also help care providers and payers to follow standardized protocols, evidence-based medicines, reimbursement programs, and in addition to increasing their reach to masses. Comprehensive use of telehealth technology for anything as vital as life can have multiple issues involving all the key stakeholders, starting from safety and security of patients and caregivers, professional indemnity to clinicians, what we heard some of the clinicians just talk about, appropriateness of technology, accountability and liability of clinical decisions, ownership's privacy and confidentiality, and use of data, aggregated training and certification of telehealth service providers. Having provided for healthcare technology in the heavily payer-driven and highly standards and protocol-based developed economies globally, we at G Healthcare can say that appropriateness of technology, well supported by fine detailed legal framework and user guidelines, can foster faster adoption of any disruptive technology. We are already providing a mature solution that from quality perspective is a medical device class 2 software, CE-marked, FDA approved, that over the years is in different markets have incorporated features to help the data-driven, evidence-based decisions to consult, advise and administer clinical decisions precisely, leading to a much larger benefit field, which we call as a precision healthcare, and therefore take care of some of the issues that we highlighted earlier today. Audit trails, data warehousing, safety checklist, standard protocols, patient customizations, patient portal, alarms and notification are some of the features that can help clinicians take data-driven decisions. And this decision can also be referenced in the future if required, ensuring clinicians' indemnity. Also on the basis of a repository of data, and these data mostly are depending upon how the institute or the clinicians wants it, are based on are kept on a server which is private to them, so nobody else can access that. These tools guide as to what would be the best treatment options for the patients concerned, apart from keeping patient data safe and providing enough transparency on their clinical treatment history. Indian innovators are already making biobots to automate retinal scanning, mammography, and ECG interpretations, some of which have matched certified professional competence. Going forward, we need to clearly elaborate on the technological specifications and the standards to ensure utmost patient and provider safety, specialized treatment protocol guidelines, certifications on treatment providers, and with passing of certain bills such as Personal Data Protection Bill and deference to the existing IT Act, the data liability and the accountability conundrum will be sorted too. The veil of ambiguity that has been slightly uncovered by the TPG undoubtedly with the distinguished institutions such as IML and forums such as this, with accelerated dialogues, discussions among relevant stakeholders and policymakers, we can help enact a comprehensive telehealth law in India that can take care of all patients, providers, technology providers, payers, etc. After all, health is important for everyone. With that, I'll take a pause and turn it over to Dr. Rindani.
Thank you
once again for having me.
Thank you. Dr. Milind Antani, I'd like to hear some crisp views coming in from you. What are the challenges? That's the topic for the day. Let's not forget ourselves, gentlemen and ladies. What are the challenges required to be overcome in the legal and the regulatory framework for telehealth, and what's the way forward? Dr. Milind Antani, to introduce him, he leads the pharma, healthcare, medical device, and digital health practice, involved with regulatory and corporate work, and also works with policy advocacy. An old friend, Milind, your views on what exactly needs to be done in challenges and how do we overcome it?
Yeah, thank you, Parag. I'll be very crisp. I don't think more than 2 minutes. I think all the concerns which have been expressed by the medical fraternity and the technical service providers are very valid. And I'll just start with 4 simple words: Shubham Karoti and Shubham Bhavati. Now, the Shubham Bhavati is going to be possible for telemedicine and telehealth, provided all the concerns which people have expressed need to be ironed out. And especially, let me start with what exactly is needed. I think the need of the hour in next year, not as fast as possible, is to have a very comprehensive, I'm using the word very comprehensive legislation which covers the entire ambit of telehealth, which also includes telemedicine. Telemedicine, telehealth are usually used, interwoven terminologies. We need to refine them. But how it can happen, I don't think it is very difficult. The TPG, the telemedicine practice guidelines that have come up on 25th March are one of the best guidelines I have seen, covering something which was required. But guideline is a guideline, even though it is a guideline. What we need to do is we have to look at the exclusions in TPG and start working out.
Like for example, what we need is a very comprehensive law which covers not only the end user, which is going to be the doctor, but we need to cover every stakeholder, which would be doctor, patient, service providers, hardware providers, as well as hospitals and independent doctors, because various models have emerged. Independent doctor providing services through some agency. So considering all these things, and of course when it goes, how exactly to manage the data, because to make people aware of the importance of data privacy, as well as cyber security. Medical fraternity per se in India is not at all savvy. I was not when I was a surgeon for 15 years, 16 years ago. So my only take is to come out with a very comprehensive telemedicine act, which includes everybody, make it a dynamic act which can be amended regularly to include new technologies are going to come, like AI, ML, 3D may also enter in sometime. And the most important point today is the biggest concern is the liability. Let me clarify, let me tell everybody that liability is the most important point for a doctor. You do not get absolved from any liability when you are doing teleconsult or telemedicine practice. All regulations, whether it is CRPC, tort law, or Consumer Protection Act, all are applicable to you. Breach of data privacy, there is a data privacy rule today. Disha was coming, unfortunately, Bedisa is smiling, info it has been shared. We both were involved, Bhagmisha was also involved in drafting that particular act. But point is, let us create a comprehensive law which defines all the roles, responsibilities, and obligations of every stakeholder. I repeat again, patient, doctor, hospital, service providers, hardwares, as well as new technologies which will encompass in very near future, so that best services are rendered, which is a need of the hour. Doctors also feel happy and comfortable. We have some kind of a defense to protect ourselves. So this is what I think my important point I would like to say. So just end by saying that end of the tunnel, always there is a light. Feel great about telemedicine practice, but be careful. It could be of a coming vehicle. So
I think you've articulated a vision statement for the Telehealth Society of India. Lots of things and all things that we can definitely work on. I'm going to give the floor next to Dr. Shrikant Shetty, who is the editor, Medical Law Cases for Doctors, member, Board of Collaborative Reviewers, Medico-legal Yearbook, and managing trustee of the Hawk Foundation. Dr. Shetty, welcome, and hello once again. Over to you. 3 to 3.5 minutes, please, on your views. What are the challenges and what can be done to improve them?
Dr. Rindani, for keeping me waiting, I think you should give me a minute more. That's the first thing.
4 minutes.
Okay, well done. I'll be very quick and I'll be brief. I'll be talking as from the end user perspective and both as the editor of the MLCD, because we are going to be getting so many cases later on. First perspective, Dr. Nagendra Swami said that there is a light at the end of the tunnel. There is always a silver lining in a pandemic. My first thing is, telemedicine has been hanging fire for so many years. It should have been implemented long back. It is like the Nirbhaya rape case happened and the rape laws were altered. So end product, is it a good thing or is it going to be worse than the previous? So that is the first perspective. Suddenly it has been let loose on doctors, and there's so much of clarification. There are so many flaws which are to be corrected, and over a period of time it will be corrected. The second point which I want to briefly come with is the guidelines have mentioned a fees which has to be collected by a doctor for giving the teleconsultation. Now the question or the confusion which a doctor has, does he collect the fees before the consultation or does he collect the fees after the consultation? If he insists on a consultation, because in India, medical consultation or advice is still considered as a social service. So the fees part is given with a lot of reluctance. Supposing the doctor insists on a fees before the consultation and the patient refuses to do so, and supposing the patient turns out to be an emergency and there are complications, then what is the liability of the doctor? If the patient agrees to give the fees after the consultation and he does not do so, what is the remedy for the doctor? This is the second problem which I am looking at. Third is the problem of first consult and the second consult. The first consultation is basically for the ailment which the doctor may have. Like say this is a patient of diabetes, I put him on some medication. Supposing there is an unrelated complication or an unrelated problem which he has. So what does the doctor do? Supposing the patient comes with kidney complaints and he is a diabetic. It may be related to the diabetes or it may be unrelated to the diabetes. So how does he go about saying whether this is the first consult or the second consult? And briefly, the guidelines mention that the doctor treats it based on his professional judgment. If the doctor is going to treat the patient based on his professional judgment, my question is then why do we have a list 0, a list A, a list B, and the last prohibited list? A doctor can base his judgment and start treatment whichever he feels is right. You don't require a list for a doctor because it is going to be the clinical acumen on a doctor. And because as you look at the list A has got certain medications which the doctor may not want to start. Let's a diabetic, a doctor has got sulfonylureas and biguanides. The doctor may want to start gliptins, and it is there in the list B, which will be advised for the follow-up consultation. So these are confusions which are going to be a big problem for the future. Does a doctor base his treatment on the list, or does he base his treatment on the his clinical acumen? And last but not the least, this is a good step for the future in the sense of patient care. But if you ask me whether it is a boon or a bane for doctors, well, time will tell. Thank you. Over to you, Dr. Indani.
Thank you very much, Dr. Sheikh. I'd just like to now quickly move over to the legal side or the legal panel. I'd like to start with Advocate Bagmishika Puhan. Bagmishika is a technology lawyer and private practitioner working with new age technology companies with special focus in finance and health tech. She is a policy advocate for telemedicine and currently serves as a legal advisor to Telemedicine Society of India, member of the executive committee of the society, also a life member of the Indian Society for Clinical Research and member legal and ethics committee academic of the Mohan Foundation. Bagmishika, impressive credentials. Let's hear what you have to say about the current telehealth laws.
Thank you, Dr. Indani. So I would just want to, from whatever we have discussed so far, privacy has been a major concern of everyone. Of course, because it is sensitive personal data, and like Mr. Bedi also mentioned earlier, the EHR standards when they first came out in 2013, they clearly made it very clear that the person whose data it is, that is the patient himself or herself, continues to be the owner of the data. So that resolved one particular issue which actually has not been addressed within the PDP bill or actually in any other legislation concerning data privacy and protection around the world as such. So that is something also that, like Dr. Antani mentioned, that's something that we can look at and we can bake into the proposed, draft that we, want to tender. Also, another important stakeholder, in addition to whatever Dr. Antani has already said, I think the TPS and the insurance providers should also be added to that particular ecosystem, because for once, I think most of us will agree that law has always followed technology. You did not have a law and then technology came later. So for once, however, immediately after TPG came in, IRDAI on its own actually took up this, released this circular or a notification which ensured that wherever OPD consultations were being allowed in a particular health insurance policy, they will also now take into account telemedicine. So it's actually, for once, we are seeing that the ball is, rolling at a good pace. So probably this is the perfect time to come up with all these suggestions and collate them and make it, present it in a palatable manner and not just, dictate it to the government to make it happen soon. One thing that I think is necessary, because there are so many private players in the ecosystem and who want a piece in the pie, there is a requirement to create a regulatory sandbox right now, get inspired from how RBI and SEBI have also done it, try to replicate that model within the healthcare ecosystem, allow the data sets which have been collected, and allow that to be presented to a set group of technology service providers, and let them work with test laws, and let them work with that particular protected environment, and see how this can actually unfold, and then use all those observations or inferences which are coming from there to then build a law which can apply to a larger group in a homogeneous system. That is also something that we have to be mindful of. With EMR and EHR, all the talks around it, it will only be possible, and interoperability will truly be possible when there is an homogeneous ecosystem, which currently is not the case in the Indian healthcare setup. So I want to say that apart from us proposing whatever in case of a draft, or trying to figure out whatever the lacunas are in the law, especially in the TPG, because I think all of us will also agree that bad law is still better than no law. You can still have the option of going and challenging it in the court and try to make it better. So I think TPG is a good step, and we should use this opportunity to build that, take up all these points that are coming from the clinician's perspective, take inputs from our side, because what is also possible and what will work in a court of law is also something that we have to think of, and then accordingly go. I think one way forward could be allowing for, requesting for a regulatory sandbox. That's my one major point from a legal standpoint.
Thank you, Advocate Bhavitsika. I'd request Advocate Mahendra Bajpai, who is an advocate at the Supreme Court of India, Editor Emeritus Medical Law Cases for Doctors, Honorable Director, Institute of Medicine and Law, to kindly enlighten us with his views and what he thinks are the challenges. Advocate Bajpai.
Thank you, Dr. Rindani. Before I express my views, as the Honorary Director of Institute of Medicine and Law, let me answer one question that was put by Dr. Ganapati. Okay. Also as an advocate, he says which authority can take cases as far as telemedicine is concerned. All those authorities where a doctor can be sued as far as physical consultations are concerned. A patient can sue that doctor for a wrong, a negligent act, a deficient act before all those forums. What it, if I was to translate it into easier terms, it means that the patient can sue the doctor before a consumer court. The patient can sue a doctor before the regulator, medical council, and can even file a criminal case. No one stops the patient from doing so. Which place, and that would be very relevant for consumer cases. So as of now, the current law, it has to be where the doctor or the hospital is there. But the new law, which has been passed but which awaits to be implemented, laws will change, and then it would be where the patient is residing or where the patient has his office. With that, I'll come to what I have to say. I endorse the views of Advocate Dr. Milind Antani. There is a need for a comprehensive law, a central law, which takes into account every aspect of telehealth, rather than the Medical Council of India bringing out a notification. Their hands are tied. They cannot bring out a notification. They cannot bring out a written law, if I could put it in simpler terms, on these all aspects. And I don't see any reason why Ayush doctor should not be permitted to practice telemedicine. So we need a comprehensive law that delves into all the aspects of telehealth, and that would be applicable to all practitioners of medicine. Why only modern medicine? I also endorse the views of Dr. Nagendra Swamy as far as telehealth is concerned, that yes, this data which is coming out from telemedicine, from telehealth must be used appropriately, must be used optimally for public health. It is required. And let us take those steps right now. As far as telemedicine is concerned, yes, there are three specific issues to which I would want to draw attention. One, permitted medicines. I do agree. More clarity is needed. Although I don't agree with Dr. Shrikant's view that let the professional judgment of the doctor take a precedence. But more clarity is required. Data privacy obviously happens to be a big concern. Please understand, in our country, the doctor-patient ratio is skewed up. In fact, in the notification itself, the MCI says that we are bringing out this telemedicine practice guidelines because of this skewed ratio. So if we want doctors to adopt telemedicine, adopt telehealth, then we have to protect them. Some protection obviously has been given in telemedicine guidelines, but more has to come. It has to be very clear. A doctor cannot be expected to be a technical person. Doctor needs to be protected on that count. And there is some confusion about the number of years where the medical records, the log books, which are used in, or rather which will be used in telemedicine, how many years they have to be preserved. Clarification needs to come from the regulator on that count also. That is all, Dr. Parag.
Thank you so much, Advocate Bajpai. So as always, you know, I always see things in a structured way. And for me, while we have the doctor, you have the lawyer, the end person who is going to look at this is going to be the patient. And for us, patient is prime. We all believe in the Latin words primum non nocere. At the end of the day, our focus is always to do no harm to the patients. That's what all doctors believe in. That's what the oath is based on. I now invite Dr. Ratna Devi, before I ask Viveka Roy Chaudhary to speak, because I think that I need a media perspective which encompasses both the doctors, the lawyers, and you know, everything coming in together. I request Dr. Ratna Devi, who is the chair of the International Alliance of Patient Organizations. It's a charity based out of the UK, she's also the founder of the Indian Alliance of Patient Groups and the founder board member of the NCD Alliance in India. Dr. Ratna Devi, we would like to understand from you, what is your view on the patient perception of telehealth? What are the challenges that he sees? Where do you as a patient, or where does the patient see himself or herself in terms of telehealth and the recipient of such services from a legal angle? Dr. Ratna Devi, over to you, ma'am.
Thank you, Dr. Rindani. And I will start with a statement that Advocate Bagmishka made, that at the end of the day, the ownership of the data is with the patient. However, in reality, this is not true. And if you see, you know, even if the patient changes one hospital to another, the electronic health records are not transferable, and therefore it starts all over again from zero. So is the patient really the owner of the data is a question that needs to be answered. The second is, though there is this telemedicine law now and everything is being discussed in a formal, background, there are lots of informal groups and chats that happen over WhatsApp and Facebook and other social media platforms. And how do we regulate those? Because the patient at the end of the day is not aware of what is the legally permissible platform and what is not a legally permissible platform. So how does the regulatory mechanism work in the country to be able to thwart those kind of platforms? The third I liked about what Dr. Swami said about telemedicine and telehealth being used more for public health good. And if the public health good has to be used, and how do we do maybe epidemiological predictions or more research using this data, then how do we also protect the patient when we are using this data, and how do we extract this data in a way that does not compromise the patient? And the last but the most important thing, when we are doing telemedicine or telehealth, how are adverse events reported? I don't think there is any methodology or mechanism that has been built for the patient or even for the provider to track and report adverse events. So if that could also be inbuilt into the system, then that would be great. Thank you.
So Dr. Ratnadevi, I'd just like to state that even in the physical world, there isn't too much of adverse event recording that is actually happening, though the mechanism is in place, both with the having written part of the standard of NABH. I can tell you that the NABH and such organizations do endeavor to ensure that people record adverse events, because at the end of the day, we really don't have Indian data about adverse events, medication errors, and so on and so forth. So I think it's important that in telemedicine, this sort of gets in on day one. Viveka Roy Chaudhary, very respected member of the Indian press in healthcare specifically. She currently is the editor of Express Pharma and Express Healthcare with the Indian Express Group, a newspaper which is very respected across the country. Viveka, your views on the current legal challenges, and where do you see the media playing a very positive role, as also the challenges, how to overcome them? Over to you, Viveka.
Thank you, Dr. Rindani.
Could we please mute our mics, please? All the other participants, request, please. Thank you so much. Yes, ma'am.
Thank you, Dr. Rindani. Define media today, because today any citizen, any patient with a mobile becomes a citizen journalist. So I would say that the patient, is probably also a liability for the system today. And if he's not convinced that his privacy is being protected, he can simply switch and become a citizen journalist. We are already seeing, as part of in these COVIDian times, a lot of patients posting their hospital bills on Twitter, on YouTube. So really speaking, as medicine is being defined as telemedicine, what is media today? A patient with a cell phone can create his own media channels. So does the telemedicine guidelines really, protect patients? I go with Dr. Ratnadevi, what she said, and I also, hark back to a lot of what the other panelists have said about, cyber security. There is in fact, Interpol has given a warning that hospitals are very vulnerable to cyber attacks. Data breaches cost the healthcare industry a whopping $4 billion last year in 2019. And it's not just phishing attacks are going to, apparently the Indian Computer Emergency Response Team has put out an alert that there are emails that are being sent offering free COVID testing. They're out to target 2 million email IDs of Indian patients. So those kind of threats which are there, how do we protect patients from these threats? How do we protect the doctors from such threats? And so as a media person, looking at all the perspectives, from the patient, from the doctor perspective, from the government perspective, yes, telemedicine is a need of our time, but how do we kind of make it safer for all stakeholders so that really there is no harm being done? Increased awareness is what needs to be kind of created, but not just awareness, also transparency, because the patient needs to feel protected as well. So increased awareness, increased transparency on all sides, and those are my two submissions at the end. Thank you so much.
I think extremely well articulated, ma'am. I'd now request Dr. Vikram Dogra, who is a professor of radiology, urology, and biomedical engineering at the Department of Imaging Science, University of Rochester, New York, USA. He's also the founder of Scientific Scholar Publication. As most of us know, radiology was the pioneering branch of medicine which actually took off on telehealth, telereporting. Dr. Dogra, your views, please.
Thank you. First of all, let me say that the mere fact that the Institute of Medicine and Law is organizing this panel discussion means that there are many issues in telehealth or telemedicine. Now, after having heard most of the eminent speakers, I'm not going to talk about the issues in radiology. I practice in USA. Here the laws are very mature, and American College of Radiology has led a way in medical communication, the form of DICOM and HL7 and other languages, which I am not going to delve into. But I have more questions, which I think is the right thing to do in this forum and to ask the panelists. Everybody has raised the question of adverse reaction, adverse events, security, all that goes to the electronic medical record. And that is the first and foremost fundamental thing we need to secure if telehealth or telemedicine has to succeed. Because there has to be portability, there has to be accountability, there has to be security, so on and so forth. The other question is this law applicable to private sector or to only hospital-based practice? I mean, government hospitals and private hospitals. There are majority of the health delivery is done by the private individual doctors in India. What about them? Are they part of this law? Are they going to participate in it? Then patient, who's the end user? Most of the health awareness, as somebody has already pointed out, is very low, and the technology is utility from the common man is so low. How are we going to educate these people to implement what we want to achieve? In summary, what we have discussed and what challenges we face are not in order of priority, but as follows. Number one is the lack of integration of the telemedicine or telehealth data with the hospital system data. Patients' lack of technical skill, reimbursement issues, expensive technology, how do we bring the cost down and implement it, privacy concerns, and the vendor selection. I will stop at this. Thank you for the opportunity.
Thank you, Dr. Dogra. I think that was extremely crisp. And we now have with us Dr. Arul Raj. Dr. Arul Raj is the chairman, Sundaram Arul Raj Hospitals, and the national president, API 2020. Dr. Arul Raj. Ravindra, can you just buzz him, please? Can you just call him? I think it's in between.
I will call him on his cell. I think he's gone for his rounds. Let's move on. We'll
okay. So before I move to a rapid fire round and give everybody an opportunity to speak, I would like to invite Justice Retired Sunil Lambwani, who is the chairperson for today's panel, to just take a few moments to introduce this eminent personality. He is the former Chief Justice of the Rajasthan High Court, appointed and served as Chairman of the E-Committee, Supreme Court of India, designated and practicing as Senior Advocate, Supreme Court of India. He is also leading the digitization effort, and he served as an arbitrator in several high-value commercial disputes. Justice Ambani ji, your views on what you've heard so far on the position that India is currently in and the difficulties that this pandemic has placed us in. Over to you, Justice Ambani ji.
Thank you very much. Can you hear me?
Yes, sir.
I've been listening to this very interesting discussion with lot of apprehensions, lot of fears, a lot of understandings which are not based on the real facts what goes on in the court of law. You see, telehealth is a very, very wide subject, very wide subject. It will cover almost everything. And the request for having a comprehensive legislation on telehealth is, I think, asking for the moon. We don't have any such comprehensive legislation to cover every profession. All we have is a regulatory mechanism and rules of etiquette, conduct, and responsibility. We cannot cover every relationship of doctor and patient, but cannot cover every kind of examination or hospital procedures, every responsibility, liability, and duty under any law. That is very, very difficult. Now, what has been done by these guidelines, which perhaps were in the pipeline, because they were brought into force on 25th of March by the Medical Council of India as regulation of etiquette and conduct. These are regulation of etiquette, ethics and conduct. These guidelines, in my view, have no comprehensive application on doctor-patient relationship. These guidelines are simply the enabler. You remember what happened when the Prime Minister said, or even in other countries, as soon as the pandemic struck, don't go for routine consultations to the doctor. Doctors do not have time. We are preparing beds. We are preparing ICUs. We are preparing ventilators. We have no time for ordinary patients or follow-ups. So doctors started shutting the shops. Some of my friends, I was aghast, surprised. They say we are turning out patients. Not because they don't want to see the patients, because they are afraid of getting the infection. Now, this kind of a scenario, the doctors feared more out of the backlash, not from the backlash of the patient, but for their own safety. So, this concept of telemedicine, which was already in pipeline, was brought into guideline by the Medical Council of India. It is not a legislation. Medical Council of India has only made regulations which have a statutory force, but it's a subordinate, it's not even a subordinate legislation. Now remember, this is a two-edged weapon. On one, it allows you to practice telemedicine. On the other hand, if you violate the provisions of telemedicine, you are liable. But I don't think there is much to fear about it. I entirely agree with Dr. Ganpati. Every day, doctors in India, whether they are in private, corporate organizations, government organizations, or practicing privately, are seeing millions of patients, writing out millions of prescriptions. How many go to court? How many actions do you find in the medical negligence? Just a few. See, criminal liability is over. The Supreme Court virtually says you cannot sue a doctor unless he is so grossly negligent that he is something which you can't think of, or he has done it purposefully, or there is a motive and malice in it. What lands up is in the consumer courts. How many cases? Why are you afraid of it? See, you don't stop driving on the road because of accidents. You don't stop riding the planes because there have been some accidents. These are the cases of gross negligence which goes to court. Mostly everything depends upon the doctor-patient relationship, which actually is nothing but a matter of trust. My father was a doctor. At the time when he used to charge 2 rupees as consultation fees, he was an MD of 1952, MD in pharmacology. I have seen him working practically. Patients always treat doctors as gods. It is only when something goes terribly wrong that something happens. So there's no need to be apprehensive about it. These guidelines are only enabler. They only enable you. But I tell you, these guidelines also don't fully protect you. They enable you to practice medicine, to give consultations. If you see guideline number 3.7.4, it talks of prescribing medicine very carefully. Proper discretion has to be exercised by the RMP, registered medical practitioner. It says prescribing medicines without appropriate diagnosis, stroke, provisional diagnosis will amount to professional misconduct. Just remember what it says. Then it says you can prescribe categories of O, A, B, but not Schedule X drugs. What is it? It only takes out the fear from you. Can I prescribe on phone? This is it, and I will say this is not for first visit of the patient. These are mostly to be followed in follow-ups. Now comes technology. I have been associated with technology in judiciary. I was the chairman of the E committee, which looks after the entire computerization of district courts. We made it very clear. Technology will not substitute judiciary. Similarly, I say here also, technology is not going to substitute medicine or the doctor-patient relationship. It will remain the same. Technology is only an enabler. You use it properly, it will help you. At present, the patient is unable to come to you. So these platforms are being created so that you can give him some. But it is up to you. It is your discretion. If you feel that the information is not sufficient, don't prescribe medicine. Ask him to come to see face to face or go and visit a doctor. There is nothing wrong in it. Now coming to data privacy and data security. May I ask you a question? Most of the doctors on the panel have been practicing for ages, decades. Who keeps the data? It is now the modern hospitals are keeping the data. The data is always kept by the patient. Whenever I go to the doctor, he says, where are your old reports? Where is your x-rays? Where are your readings? Where are your MRI reports? Who's keeping the data? I am the owner of the data. It is my own data which I have to protect. Why are you bothered about it? Why are you worried about it? And suppose there is a cyber attack and the data goes. Do you think the entire hospital will be sued by me? The problem arises when the hospital starts thinking that it is my data. You know, whenever I go to the doctor, he says, get a fresh examination done. You go to the new hospital, fresh examination done. I say, I have got it done in Max, Apollo. Can you ask them to give the data? They will never give. So Bhagavata rightly says, the patient is ultimately the owner of the data. Give it to him. Ask him to protect it and keep it. Every patient has a smartphone now. He can keep his own data, the prescriptions, the reports, and other things. Don't bother about the privacy and security of it. He will bother the privacy and security of it. When you start bothering the privacy and security of data, you start trying to own the patient and his data. That is not the right thing. That's my view about it. Now comes how are you looking at the whole thing? The telemedicine or telehealth. Is it doctor-centric or patient-centric? If it is patient-centric, I think your perception will change. If you will only think of your liability, the patient suing you, you will certainly have a lot of questions to ask. Don't bother about how many patients sue you. I ask all of you, how many cases are you facing in court or before the Consumer Protection Act? Then why are you talking hours and hours on your liability and protecting your liability? These telemedicine guidelines were brought in only so that the doctors do not shut the shops. And really, please do not delve in the atmosphere of fear. Patient is afraid, not the doctor. I am afraid, I am sick, I am coming to you. I need the trust, the good faith, the requirement of reasonable care. So long as you give it, nothing is wrong. I tell you, as a judge, if any case would come to me, the scales of justice was always shift in favor of the doctor, because doctor is still seen as a god. Protect your image, protect your the work which you are doing excellently good, and this is what we require. This is a very trying times. I think the COVID times are going to be over very soon. News is coming that the vaccine is on the cards. As soon as the vaccine comes, I think we'll all be practically safe. And for the rest of the things, we have to follow our own safety. If there is any more thing that you require, I will always be there at the end of the session. Thank you.
Thank you. Justice Ambaniji, we are coming to the end of the session, and I would request, I think Dr. Sood, if you can wind up your 2 slides which you have requested in about 30 to 40 seconds, I'll be obliged.
Sure, sir. I'll wait.
So please go ahead.
In fact, sir, we, with due regards to every stakeholder in healthcare domain, I would say that, and everybody has acknowledged it, healthcare sector is a laggard as far as adoption of IT is concerned. And not only that, the consumers of healthcare services are even bigger laggards or bigger irresponsible, I would say, actors. This is an excerpt from one of the privacy policies of one of the telemedicine applications. Those have been in place, or those have been in the market for quite some time. And I feel that they are openly saying here that they do not promise, and you should not expect that your personally identifiable information or private communications would always remain private. I'm not reading it out of context, but then they also say that we may share our data, including your personal information, with our parent or subsidiaries, etc. So these are the challenges which people are agreeing to. They are yet not sensitive to the personal information is so critical or crucial or confidential, and the government is working towards a platform which is going to be launched very soon. It is called Pradhan Mantri Jan Arogya Setu, which is all about One India and One Health platform, wherein they'll work towards creating a health ID, which is the biggest challenge as of now in terms of standards, and ID for every entity in the healthcare service chain. Ayushman ID would be the healthcare ID of the individual, the patient, the doctor ID under the doctor registry, and also the healthcare facility. And this all will get connected with the patient's health records, wherein they can interchangeably or interoperably use the information. So that is what I wanted to share, that government is working towards these aspects, but then it will take some time. By parallelly, the patient also has to be sensitive about the information that is being shared or that is being permitted to be used by the telemedicine applications or healthcare providers for that matter. So that is all I wanted to share. This could add some more dimension to the concerns.
Well, thank you very much. I did time it and it was 38 seconds. Thank you very much, Dr. Sood. I think with people like you at CDAC, we definitely will do well. I'm going to now ask Advocate Bajpai from Institute of Medicine and Law to Bajpai ji.
Yeah, Dr. Parag.
हमें लगा सोशल डिस्टेंसिंग में आप हमारे से दूर चले गए सर. Advocate Bajpai, if I may request you to kindly wind up and give closing comments, please, before we move on to the vote of thanks.
Broadly, under the telehealth, I'll be summarizing under two different categories, telehealth and telemedicine. So under telemedicine, one big concern is whether doctors are legally safe, permissible medicines, indemnification, insurance, and state-specific licenses, laws, interoperability, their absence, keeping records, if data is lost by the company, by the operator, by the platform. These are concerns. Blackmailing by the operators. Then when the patient happens to be outside, repeated use of prescriptions, friendly advice, which was not a professional advice. What should be done when the audio video is not good? Obviously, prevention happens to be better than cure. Fees happens to be another area of concern as far as telemedicine is concerned. First consult, second consult, there are some gray areas which need to be addressed. And a very good suggestion which came from Dr. Shrikant, that if professional judgment of the doctor has been given this much importance, let the doctor decide about the permitted lists. Let his clinical acumenship decide. Adverse reporting obviously needs to be addressed. As far as telehealth is concerned, there is a lot of apprehension about security of data, about privacy, about commercialization. We did come to know that yes, NABH and QCI are working towards standardizing practice of telehealth, data ownership, privacy of EHR, EMR, they remain
almost
the definition obviously has to be many definitions need further clarification. This course has to be introduced, or rather telehealth, telemedicine, they have to be introduced at an undergraduate level, so the doctors who come out, they are well versed with it. Remote sensing systems, they have to be regulated. Dr. Bhattacharya gave an excellent example of Israel. EMR, doctors are being charged deeply. What should be done? Regulators, the policymakers need to address this cause of concern. Dr. Nagendra Swami as well as Dr. Ratna Devi, both of them spoke about public health, how this data can be used for prediction, for surveillance. Dr. Advocate Bamshika, she also came out with very good recommendations about bringing in regulations the way SEBI and RBI have brought in certain regulations. Regarding interoperability also, there are concerns, cyber security, but as put secondly put by Justice Ambawani, there is a lot of misunderstanding that needs to be clarified. Apprehensions are there. They need to be addressed by proper awareness. That is all, Dr. Parag. Dr. Dilip had Walke, who happened to be the convener, was to summarize, but he has some issues with his internet. So I did the summarization. Thank you, friends, for listening patiently, for participating enthusiastically. And now I hand it over to Parag. Thank you, Parag.
Parag is out for a moment, so it is back to me.
Very much sure. Very much sure. Thank you, Ravindra.
Okay. Okay.
I'd like to have closing comments.
Dr. Parag, this is Dr. Goyal here. Just a moment for 1 second correction.
Yes, sir.
This is was referring to Mr. Mahendra Kumar's talk. I would like to inform you that the government has already come out with the telemedicine practice guidelines for the homeopathy practitioners on the 10th of April, and also the Ayush, Siddha and Unani practitioners on the 7th of April. That's a piece of information for you in case you didn't know that.
Yes, agreed.
Great. Thank you very much for that update. I'd like to have Dr. Walke to please give his closing remarks. Sir?
Yeah, thank you. In fact, Advocate Bajpayee has already done the summarizing. Thank you very much, Parag, for you have the knack of getting the best out of every panelist. And you also is a soft Arnav Goswami, I must say that you can stop people when you want to make them stop. Thank you very much for a wonderful panel, and I think I should not waste time summarizing it anymore. Just few points which I thought we needed to discuss. One was the point on the prescription doubling. I mean, there was somebody who talked about doubling of prescription. You can easily take a screenshot and you can take medicine from different pharmacies. So I just wanted to put a thought whether a barcoding of the prescription can take care of this. So that can be one way to look forward onto it. About confidentiality and privacy, I mean, since there are so many advocates sitting here, can there be a non-disclosure agreement that can be framed by the government so that every private platform provider, essentially, when there will be a legislation for the private platform providers, essentially they will have to sign this non-disclosure agreement so that all this data will be protected and there will be homogeneity of the data at one server. Also, the last thing that I thought was important that in the prohibited list of drugs, there are anti-cancer drugs and antipsychotic drugs. I think we need to also do a little bit of advocacy on that, because if there are any any patients who need teleconsultation, then they are the psychiatry patients, and then there are these patients who are on chemotherapy. So these are the ones who need a lot of telemedicine. Yeah? An oncologist need to talk to another RMP on telemedicine for the chemotherapy practices. So I think these are a few points that probably the clinician missed out. So instead of summarizing, I thought I would just leave you all with these 2 or 3 points which you can think of and then put in the white paper too.
I will take the liberty of being the moderator to request Dr. Arulraj to please say a few words. He's been kind enough to come back after his rounds. Dr. Arulraj, can you please give your a few comments on the current situation?
I'll just, briefly share my mind. I was attending the major portion of the, discussions. It was well focused. I am a proponent or rather passionate about, digital learning and digital health for a long time. Right from Commonwealth, we have been doing that. But now I am so happy after our discussion with our Honorable Prime Minister, they have legalized it. All of you know Mumbai High Court has banned it. We made an expression to our Honorable Prime Minister. The next day, MCA issued the order. Thanks for the same. After that, with Soothe and their help, this e-Sanjeevani has come at free of cost. I'm really good. I have 2 concerns. One is on the legal side of it. What is there on the legal side is, see, it facilitates a connection between the caregiver and care provider, distantly, not by personal, touch. And in medicine, we always used to say, as for Hippocrates, nothing can replace a doctor's touch on the patient. That is being replaced, number 1. Number 2, on a video consultation, which is of a good quality with Sanjeevani, still errors are possible. Because we are going to decide on what the patient says, but not on what the doctor examines and evaluates. That is, we are basing a diagnosis on symptoms and the laboratory report he is going to show, but not on the signs that the doctor elicits, because that forms the basis of clinical diagnosis that is missing here. Why I am saying this is, there is a chance for error on the diagnosis. When diagnostic error is there, treatment error also will be there. Then the doctor will be legally responsible if something bad comes to the patient. That is where I am concerned. And the solution for that is a legal liability has to be removed. That should be a caveat on this act. And legal liability should not be pushed on the doctor based on a teleconsultation and a teleprescription. The second area is, I think, all the people, made that point. Even Ratna also made a point. That is safety and security of the, privacy and security of the data. See, these data can be pushed anywhere, either to the government for preparation of an epidemiological data, or can be even, I don't want to go into the, intricacies, can always be sold to industry, this and that, everything. That is one aspect of it, converting the EHR into a business. Secondly, a privacy. See, that patient data is the only person responsible for the, owner for that is he and he himself. And this definitely opens up the platform, for other persons to access it. Actually, we have discussed enough on that. And now, they have put in a blockchain security to that, but that seems to be fairly reasonable. The password will be with the patient. But still, now there are recent reports that even that could be bypassed, and the secrecy or rather privacy can always, cannot be always, assured to the patient. These are the 2 major legal aspects of it. And the technical sides of it, video is good. But, the time duration, in Sanjeevani, it has been kept as 7 minutes. There should be an option to extend. Secondly, thirdly, now Sanjeevani is a free app and there are no financials involved. But when financials are involved, there should be a very definite, clear-cut payment gateway system has to be there. And then this EMR that is being created, or EHR, whatever label we give it, has to be still more perfect. That, they have done it so well. but still more some data have to be added and see that this is being, made still more perfect. And the last point I would like to say is this can definitely generate e-prescriptions. And e-prescriptions are, being misused like anything by many of these industry people. There I want to put a small caveat. Thank you so much. Anybody could give something, add on this, I'll be too happy. And telemedicine is order of the day. We can't avoid. Whether there is corona or not, we can't avoid. Because a patient from Mumbai, I gave an example, before he reaches the hospital, many times something bad happens. Therefore, the elimination of the distance and timing has to be there, and we need to reach to the nooks and corners of our great country. Therefore, this is a must. Lot of regulations have been done, lot of fine tuning is done. Now our legal people are also there, they can also apply their mind, make it little more perfect so that doctor is safe, patient is safe, his record is safe. Thank you very much.
Thank you so much, Dr. Arulraj. Thank you.
Sorry, can I just make an important observation, please? Ganapati here.
In 30 seconds, yes, Dr. Ganapati.
Yeah, 20 seconds. Dr. Arulraj, I beg to differ with you. I'll be happy to share hundreds of videos where we have done detailed clinical examination of a patient. I don't want to take time. I'll be happy to share any number of videos with you.
Kindly
I
share,
don't
sir.
agree with your statement.
With
We can
simulators also we are
clinically
doing
examine
it,
a patient.
but in spite of it, nothing can replace a clinical examination, sir. I beg to differ.
Anyway, excellent, sir. I think there are views both for and against, as always happens. And as somebody articulated earlier, we are the world's largest democracy, and we are the world's most vocal democracy. So, with that, ladies and gentlemen, I'd like to thank you on a personal note and hand over to the COO of Institute of Medicine and Law, Mr. Agastya Matre. Agastya, over to you, please.
Dr. Parag, am I audible?
Yes, you are.
Yeah. That was a wonderful session, gentlemen, we had today. I would like to start my vote of thanks with respected chairperson, Dr. Justice Sunil Ambani ji, our esteemed panelists, viewers, and colleagues from the Institute of Medicine and Law. I thank you all, behalf on Institute of Medicine and Law, for putting your efforts and make this 5th National Convention, Medicine and Law, a great success. We are grateful to Justice Sunil Ambani ji. Sir, you have been a friend, philosopher, and guide for today's deliberation. Special thank you for our conveners, Dr. T.N. Ravi Shankar and Dr. Dilip Walke, for guiding the proceedings towards a meaningful interaction. Thank you, Dr. Parag Rindani, for moderating the sessions so efficiently, so effortlessly, and that too when you are facing some really big challenges at your own hospital. Thanks to Sanofi, GE Healthcare, Express Healthcare for your invaluable support. We receive a lot of support across from the globe, but a few needs to be thanked, specifically Dr. Juice from CDC Foundation, United States, and 2 organizations, namely Resolve to Save Lives, an initiative by Vital Strategies, again from United States, and the DLT Foundation, Spain. There are many more should be thanked specifically, but time is a constraint. Once again, to one and all, to those who viewed, supported, and participated the 5th National Convention on Medicine and Law 2020, a big thank you for all of you for making it a big grand success. Thank you.
Thank you very much. Good day, ladies and gentlemen.
Thank you, everybody. Have a pleasant day. Bye.
Thank you. Goodbye.
Goodbye, everyone.